morning, thank you. Please be seated. Okay, good morning. We're here outside the presence of the jury, 214-2024 CR 0028, State of New Hampshire versus Dustin Duren. Good morning, counsel. Morning, Mr. Duren. And I know that after the close of business, I did circulate the jury instructions consistent, well, what I believe with my orders yesterday. And Attorney Kettles, looks like you have a question. Is it on that or on something else?
Yes, Your Honor. And maintaining all of the previous arguments we made yesterday, I just wanted to point out one additional note based on the draft that was circulated last night. Starting at the bottom of page 12, continuing on about halfway through page 13, the discussion about the distinction between deadly and non-deadly force, we would ask that that be stricken. I don't think there's any dispute in this case that the force used was deadly, and so I think it is confusing to the jury to have them be doing this weighing of deadly versus non-deadly force, especially in this coming after the second-degree murder knowing charge where deadly force is not one of the elements, caused the death of another is one of the elements.
Okay, and I note that in the defendant's submission, which I denied yesterday and is again colloquially known in these parts as the NOMAR instruction, that in the defendant's requested instruction, there was a definition of deadly force that was in the defendant's overall requested instructions. I would note that for the record.
Yes, Judge, and reading the current version of the instructions, I think that this series of drafts with what the current instructions are a little bit confusing. And so just seeking to have the clearest and most simple language possible for the jury based on the court's ruling yesterday.
Okay, understood. Anything further, Attorney Kettles?
No, Your Honor.
Okay.
We disagree, Your Honor. We think these instructions are appropriate. They were contained in previous drafts as they are in this final draft. I don't think there's any reason to take them out. I don't believe it would be confusing for the jury to understand the difference between deadly force and non-deadly force in a situation where they were going to hear arguments after hearing testimony about someone who fired a gun at someone for allegedly hugging someone too tight. I think that's deadly force. That's not deadly force. It's important to know the difference.
Okay, all right.
And so, Judge, that sounds like the state wants this instruction not as it goes to Mr. Duren's use of force, which is the purpose, but to try to somehow bolster the actions of Ms. Naffziger, which is an improper purpose. If there's going to be an instruction on deadly force, it should be about the defendant's use of deadly versus non-deadly force. And the state just said that's not why they want it. They want it for a different and, I think, impermissible purpose.
I would disagree with counsel's characterization of the state's argument. I don't think there's anything else that the state needs to say.
Okay, all right. Anything further, either party?
No, Your Honor.
Okay, all right. Defendant's request is noted. Defendant's request relative to that removal of that instruction is denied based upon the arguments contained by counsel, also based upon arguments as referenced yesterday during the charging conference, the lengthy charging conference, and also based upon the defendant's submission relative to jury instructions, which did include a requested definition relative to deadly force. I think that based upon the overall circumstances, the instructions adequately and reasonably set forth the issues for the jury to be decided with respect to this matter. So over the defendant's objection, that specific portion of the instructions will remain in as drafted, as prepared. Anything further, Attorney Kettles?
No, Your Honor.
Okay, Attorney Spicer, anything further?
No.
Okay. All right. Last bit of business, which I just want to make sure I want to make sure that during just relates to logistics. I want to be able to make sure that I've established that I can I think under the circumstances, the best thing is to go back where it was yesterday, and I will simply move down to that portion.
gonna take us at least 20 minutes, Your Honor, of taping wires and moving the equipment and resetting up another monitor.
No, when I said yesterday, I meant at the end of the day yesterday. I just meant shifting that to
Back to where it was.
this morning.
This is over here, over this way. This morning.
This morning.
I'm not, no, I'm not talking about,
Thank you, I thought you meant
No.
moving it all the way this way, Your Honor,
Yeah.
I apologize.
yeah, I think,
And if the court, Your Honor, if the court needs or requires it after we're done with closing and before, when the court is instructing, we can disconnect the cords and move the TV straight across the room.
yeah, no, I think under the circumstances, I think if I'm here, then I can maintain the most, it's a rather narrow angle, it's a narrow angle of being blocked, but I think I can see, everything I need to be able to see for purposes of the record. If I position myself here, any objection from the state relative to anything?
No, Your Honor, we do appreciate it.
Okay, anything from defendant if I,
No, Your Honor, I just note that we now can't see that screen, so I just like to test, the state has said that this
Yeah,
should still
this
work, but I'd
player is
like to
still
test
working.
it before the jury comes in, since we now can't see that.
please.
If you could just turn it on and make sure it's connected.
So I should ask Madam Clerk, do you object if I? Okay.
Is your monitor power on?
Yes. It's working on the judge's bench. We're not seeing anything on your judge. I think before you had to wiggle the wires. So we'll have to test before the jury came in. Blue light, HDMI, there's signal. Went blue screen to no screen.
Blue light's on, there we go.
Okay.
Attorney Callis, are you
We can now see this, yes.
up and running? Okay. So once again, please let the record reflect that based upon the configuration of the courtroom, the court does find it to be in the interest of the jury and in the interest of those in attendance, as well as counsel. It appears that everybody has the ability to see the monitor. Judge, I will move down to a position directly behind the clerk's bench, from which vantage point, let the record reflect that I will be able to maintain visual contact with the jury as well as the parties in this case, and I've consulted with counsel as to that issue, and there's no objection, so I think we should be sufficient under the circumstances. If an issue does arise, of course, I reserve the right to momentarily pause the proceedings in order to bring some, whatever change is necessary under the circumstances. Anything further from the state before we line up the jury?
There we
No.
go, thank you. No, Your Honor.
Okay. Anything further from the defense?
No,
At
you're
this
not.
point? Okay, all right. Thank you. Thank you. Thank you.
All rise for the honorable jury. Owens County Superior Court is now in session. The Honorable Jonathan F. Frizell presiding.
Okay, good morning, thank you. Please be seated. Okay, good morning, members of the jury. Thank you for your punctuality, thank you for your service. As I told you yesterday, we're about to proceed with closing arguments from the defendant and from the state, and you'll also hear my instructions to you before you retire to the jury deliberation room to decide your verdict. The first matter, obviously, you can see in order to allow the presentation of certain items with respect on the screen, the screen has been moved over here. As a result of that, I'm stepping down here so that I can maintain visual contact with you folks as part of this proceeding. So I will do that during the closing arguments, and I've consulted with the lawyers, and they're in agreement with that. So I will be moving down here just so that I can continue to see what's happening. I can also see the screen from where I am here. So the first order of business, as I mention every morning, because there has been a media presence with respect to this trial, I again ask you if you have had any exposure to any of the media coverage, any information outside the confines of this courtroom, even if it was inadvertent. If you have received any such exposure, I would ask that you please raise your hand to indicate so, and we will address it at that time. Okay, please let the record reflect that none of the jurors raised their hands, so thank you again for following my instructions in that regard. And we are now at the point of closing arguments. And again, closing arguments, jury instructions, then at that point you will, once I give you the permission, you will be able to talk about the case and the evidence at that time. Okay, so anything further, either counsel before closings? Okay, I will, if you give me 1 second, Attorney Kettles, I'll move down here. I've been offered the clerk's bench. I'll take the clerk's bench. That. Okay, thank you very much.
The law says that Dustin Duren is not guilty. The law says that Dustin was justified when he shot Caitlyn Naffziger. The law says a person has the right to use deadly force when they reasonably believe that someone is committing or about to commit a kidnapping. Caitlyn had kidnapped Dustin's child before. She had a plan to kidnap his children again. She told Dustin he would never see his children again, and she was holding Elowen hostage in front of him. Dustin reasonably believed that Caitlyn was committing or about to commit a kidnapping. Dustin Duren is not guilty. This is a case of secret plans, broken promises, and a father's unyielding love. It is about a Marine reacting to a threat toward his beloved daughter. A horrific tragedy, but not a criminal offense. The law says that Dustin Duren was justified when he shot Caitlyn Naffziger. Dustin Duren is not guilty. Caitlyn Naffziger went to Dustin's apartment in Berlin in late February 2024 under false pretenses. She told him that she was there to drop off his daughter Valen, but she was actually there with a secret plan that she came up with together with her Aunt Brenda, a secret plan to take both kids to Minnesota without Dustin knowing, a secret plan to kidnap the children. And it wasn't the first time that Caitlyn Naffziger had kidnapped one of their children. When the family lived in Las Vegas, Caitlyn walked out of the house with baby Valen in a stroller. She pretended she was going to the park. Hours later, she hadn't returned. Dustin went to the park to look for them, and they weren't there. Caitlyn had taken the baby not to the park, but to the airport. She was flying to Minnesota with their baby, moving out of the state with Dustin's child, without telling him,
without getting his agreement, without even letting him say goodbye. Caitlyn had kidnapped Dustin's child before, and when she came to New Hampshire, she planned to do it again. Caitlyn and Brenda had a secret plan to kidnap the kids, to unlawfully interfere with Dustin's custodial rights, to take both Elowen and Valen to Minnesota without even telling Dustin. But that secret plan was interrupted. Caitlyn had to change her plan once Dustin began to figure out that something wasn't right. And here's what happened. First, Brenda drops Caitlyn off at the restaurant rather than sticking around to take Caitlyn back to her place in Hampton. Then, Caitlyn wants to go back to Dustin's apartment in Berlin, where she had told him before she didn't want to stay. The next day, Caitlyn won't tell him when she is planning to leave. Caitlyn is acting suspiciously. She's ignoring him, doing something on her phone, refusing to engage about what is happening with their children and what she is planning to do. And this is the exact same thing that she did last time she kidnapped one of their children. And so Dustin is getting more and more suspicious. After Caitlyn ignores him all afternoon, Dustin decides that Caitlyn, who's refusing to communicate with him, is no longer welcome in his apartment. He tells her she needs to leave. She ignores him again. He tells Caitlyn it's time to leave and he will drive her back to Brenda's place. And to get ready to go, he puts Valen in the car seat near the kitchen. And when Dustin tells Caitlyn that she's no longer welcome at his place, Caitlyn's secret plan to kidnap the children is interrupted. Caitlyn realizes she is not going to be able to steal the kids away from Dustin without him knowing. And so Caitlyn changes her plan. She reacts. She grabs Elowen to use her as leverage, to use her as a pawn to try to enact the plan. Dustin comes back into the living room and sees Caitlyn sitting on the couch, holding Elowen from behind. Elowen is straddled on Caitlyn's knee. Dustin tells Caitlyn, "Come on, we're leaving," and tries to grab Elowen to get Elowen ready to go. But Caitlyn refuses to let Elowen go. She grabs Elowen and she pulls her back. And Dustin lets go because he doesn't want to engage in a physical struggle with Caitlyn over their child. So he again asks. He starts to beg Caitlyn to let go of Elowen. Caitlyn refuses. She says no. And at this point, Dustin's internal radar is going off. Caitlyn is refusing to release their child. She's physically restraining her. She's putting her at risk. And Caitlyn has been acting suspiciously. She's been acting the same way that she did last time she kidnapped one of their children. Caitlyn is beginning to become a threat. Dustin is a Marine. He's trained to respond to threats, and he's responding at this point in the way he has been trained. He's at condition orange. He feels there is a danger to his child, and at condition orange, he's focused in solely on that threat and his need to protect his child. Dustin is begging and pleading with Caitlyn to just let Elowen go. And Caitlyn again refuses. Caitlyn tells him that unless he pays her $2,000 a month, she is taking the children back to Minnesota and he will never see them again. Let's be clear, she is not asking for child support. She is not asking for money to help her take care of the children. She is asking for money so that he can have the children. She's asking him to pay her money so that he can keep the children. At this point, she's holding Dustin's child hostage, holding her for ransom, saying that she'll only release her if he gives her money. And she's also threatening to call the police and to lie to them, to tell them that Dustin took Elowen to Berlin without permission, and that she's going to lie to the police unless he gives her money. And while she's threatening to take his children from him and make sure that he never sees them again, she's continuing to confine, to restrain their child. Dustin feels like this is a hostage situation. Elowyn isn't safe. He's panicking. He keeps begging and pleading, begging Caitlyn to just let Elowyn go. She refuses. She continues her threats that Dustin will never see the children again, that she is taking them from him. And she continues to confine Elowyn in her arms. At this point, the tension is rising. Valen is crying from her car seat in the other room, and Elowyn is crying, both from the argument and from being physically restrained by Caitlyn. The situation is overwhelming. Dustin is scared for Elowyn. He needs to make sure that she's safe. His fatherly instincts, his protective instincts, are telling him that something is seriously wrong. The woman who kidnapped his child before is telling him she's going to do it again. And this time, he can see her physically holding their child hostage. Dustin, trying again to protect his daughter, tries to take Elowyn for the second time. And Caitlyn pulls her, yanks back again, and Dustin lets go. Caitlyn continues her threats to take the children and ensure that Dustin never sees them again. Caitlyn is escalating. She's getting more and more aggressive. She's kidnapped one of their children before. She's threatened to take them from him before, but this time is different. This time, she's holding his daughter hostage, holding her for ransom right in front of him. This time, she's confining his daughter, restraining his daughter, using physical force against his daughter. And Caitlyn had been on the phone. Dustin's thinking, is there someone outside, maybe Brenda, waiting? He's thinking, she's saying she's taking my kids from me. She must have a plan. And Dustin tries one more time to take Elowyn, to free her, to make sure she's safe. This time, he tries harder. He tries to grab one of Caitlyn's wrists with one hand and wrap his arm behind Elowyn with another so that he can free Elowyn from Caitlyn's restraint. But instead of letting go, Caitlyn gets more aggressive, more physical. Caitlyn braces her leg against the table. She yanks back even harder than she has before. She pulls, she twists, she bear hugs Elowyn. And Elowyn lets out a scream, a cry of pain from being yanked back by Caitlyn. Dustin and Elowyn lock eyes, and Dustin sees Elowyn's fear and her pain. And hearing Elowyn scream is horrific. It's a line that has been crossed. Elowyn is about to be kidnapped. Elowyn is in immediate danger. And so Dustin acts immediately. And he very, very quickly, with deliberate motion and without conscious thought, acts the way that he has been trained. The only thing in his mind is save Elowyn. His internal radar goes into condition red when a threat is so immediate, a danger so imminent that you need to take action. Like he had been trained, instinctually, automatically, he grabs his gun, chambers around, grabs the collar of Elowyn's shirt with one hand, and pulls her as far toward him as he can while Caitlyn is still restraining him. And while Elowyn is still in Caitlyn's arms, still being held hostage, he fires a single shot. And immediately after he shoots, Elowyn is released from Caitlyn's arms, and she is freed. Elowyn wraps her arms around Dustin, and he runs out of the house and puts her in the car. He talks to Elowyn and makes sure that she is physically unharmed. But he's still in this heightened mode, this need to protect his kids. He grabs what he thinks they would need, He puts Valen in the car and he drives. And once he's on his way, once he knows both kids are safe, once he's out of condition red, he feels horrible. What has happened is tragic. Caitlyn is someone he cares about and who is important to him and his children. He knew that he had been acting to save Elwyn, but that doesn't mean he isn't devastated by what just happened. And he knows he needs to turn himself in, but he wants to spend some time with the girls first to make sure that they are unharmed, to make sure that they are okay, not just physically, but mentally. He calls his mom. He tells her he shot Caitlyn. He tells her to call the police. And then he turns his phone off so he can have some time with the girls. And he drives, checking in on the girls along the way. The following morning, he turns around and heads back to New Hampshire to turn himself in. And he is hoping to have a meal with the girls before he does so. But the police locate him first. He cooperates, he complies with their commands, he makes sure they know that there are children in the car and exactly where his gun is located. And he does these things to make sure his children are safe. And then he speaks with the police, voluntarily, although he's under no obligation to do so. He's still in shock when he tells them what has happened. He feels horrible about what has happened, and he doesn't want to blame Caitlyn. He doesn't know New Hampshire's law on justification, and he doesn't know the law of defense of others. All he knows is that he was acting to protect Elwyn. When the state played the video of his interview, the last thing we heard Dustin say was about Elwyn. He says, not that it even justifies anything, but it's like, she's just my everything. And Dustin's right that Elwyn is his everything, but he doesn't know the law. The law says that Dustin is justified. The law says that Dustin is not guilty. The judge will instruct you on the law. He will tell you, evidence has been presented that Dustin acted in defense of another with respect to each of the charges. He will tell you that you must find Dustin not guilty unless the state proves beyond a reasonable doubt that he did not act in defense of another. And the state cannot meet its burden. Dustin did act in defense of Elwyn. He is not guilty. The judge will tell you that when looking at the evidence that Dustin acted in defense of Elwyn, you should consider all the circumstances surrounding the incident. You should consider how he acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. The judge will tell you that Dustin had the right to use deadly force to defend Elwyn if he reasonably believed that Caitlyn was committing or about to commit a kidnapping. Dustin's belief that Caitlyn was about to commit a kidnapping was reasonable. Dustin had the right to use deadly force. Dustin is not guilty. And consider all the evidence you've heard that Caitlyn was about to commit a kidnapping. And I'm going to highlight just 4 of the many things that you've heard. First, Caitlyn's own aunt told you that Caitlyn had a plan to take the children to another state without telling Dustin. Second, Caitlyn had kidnapped one of their children before, Caitlyn had taken one of their children, pretended she was going to the park, and actually gone to the airport to take Valen out of state, to move her to Minnesota without even letting Dustin know. Third, Caitlyn was holding Elwyn hostage, telling Dustin he was never going to see either of their children again. And fourth, Caitlyn was willing to harm Elwyn rather than let her go. Caitlyn was in fact attempting to commit a kidnapping. We heard it from her own family member. And therefore, Dustin's belief that she was about to commit a kidnapping is not only reasonable, it's correct. During jury selection, we talked about the fact that parents have a responsibility, a duty, to protect their children. And that's what Dustin was doing. He was protecting his child, ensuring she was not kidnapped. The facts are clear. Caitlyn was about to commit a kidnapping. You heard it from Brenda, and you heard it from Dustin. The law is clear. Because Dustin reasonably believed that Caitlyn was about to commit a kidnapping, Dustin had the right to use deadly force. Dustin is not guilty. The state gets to make its closing argument last, and Dustin won't have the opportunity to respond. So let's talk a little bit about what the state is likely going to say and about the evidence the state presented or didn't present during the trial. First, you should not automatically believe that what the state is telling you is correct. The state showed you that in its opening statement. The state's claims about what the evidence would be in its opening statement were wrong, and they were misleading. Here's one example of when they were wrong about the evidence. The state told you, even put up on its big fancy screen, that Dustin was asked, "Fair to say you know you are endangering Elwyn," and that he said yes. But the sergeant, the police officer, the state's own witness, told you that what actually happened was the exact opposite. Dustin said, "Could it be that I'm endangering Elwyn by what I did?" And I would very much say no. Dustin was asked, "Fair to say you know you weren't endangering Elwyn," and that's what he said yes to. What the state told you about the evidence was wrong. What the state told you about the evidence was misleading. It told you that Dustin said the shooting was very deliberate, but it didn't tell you that that wasn't all he said. He said it was very, very fast, very deliberate. And that was misleading. That left out half the sentence to create a misimpression. The state also got it wrong when they said that Dustin grabbed Elwyn, she was in his arms, he stepped back, and then he shot. That's what the state said happened in its opening statement, and that's not what happened. And the state knows that's not what happened. The state had proof in their evidence that what they are saying happened is not true. Their claim that he had Elwyn in his arms and stepped back is not true. How do we know that? We know that because the range of fire was close enough that Caitlyn's hair got caught in the slide of the gun.
Objection. May counsel approach?
Members of the jury, I'm instructing you, I'm striking the last sentence from the closing argument and instructing you to disregard it, and I will return to my seat now. Okay, thank you.
This is State's Exhibit 24A. They didn't talk to you too much about State's Exhibit 24A. They talked to you about the gun, but not about the other half of the picture. The other half of the picture says, hair removed from slide. So be able to take it back with you, and you can see it right now. The police tampered with the evidence. They took the hair
Objection.
from the slide.
May counsel approach?
Yes. excuse me, members of the jury, I'm striking the last sentence of the defendant's closing argument based upon the totality of the evidence that has been submitted. Also, there was no evidence adduced during trial of any improper action in the collection of forensic data. Attorney Kettles, you may proceed.
States 24A shows that hair was removed from the slide.
The state didn't present any evidence that it tested the hair. The state didn't present any evidence about whose hair it was. The state didn't have its witnesses talk to you about the hair that was removed from the slide of the gun. And the state didn't talk about the fact that hair had been removed from the slide of the gun during its opening argument. And we can't know whose hair that was because the state didn't present any evidence, because the state didn't test it. But we can think about whose hair it must have been. We can think about where Dustin said his arm was when he fired, and where Caitlyn was in relation to that gun and the slide of that gun. We can think about the fact that Caitlyn's hair wouldn't have gotten caught in the slide of the gun if he had grabbed Elowen, taken a step back, and then shot. Caitlyn was still holding, still restraining, still confining Elowen when Dustin shot her. Dustin was justified. Dustin explained to you that Caitlyn was still bear hugging, still restraining Elowen when he fired the gun. He explained to you that he pulled onto the collar of Elowen's shirt with one hand to pull her forward to try to get her, but that she wasn't released from Caitlyn's arms. She wasn't safe until after he shot. The state may try to argue that that's not what he told the police, but you have the video. Watch it. They say that he stepped back. Nowhere in that interview does it say that he stepped back. Nowhere in that interview does he say that Caitlyn had let go before Elowen was shot. I apologize, that Caitlyn had let go of Elowen before he shot. I expect the state will make a big deal of the fact that the medical examiner told you that there was no evidence of close-range firing. But that just means that some of the markers that the medical examiner would look for weren't there. The medical examiner told you that he couldn't say exactly where the shot was fired. He said that it's possible, he said on cross-examination, that it's possible to fire from close range without those markers being there, especially when there is hair overlying the entry wound, like there was in this case. There wouldn't be gunshot residue on the skin if there was hair in the way, and there's been no evidence presented that the state tested Caitlyn's hair for gunshot residue. You have better evidence than the medical examiner, who can't say anything with 100% certainty, who wasn't there, who doesn't know whether or not this was justified. You have the photos from the apartment and from the autopsy. I'm not going to put them up again. But Caitlyn was sitting on the couch facing forward. She was shot in the side of the head. Dustin couldn't have had Elwyn in his arms, taken a step back, and then shot. If he had done that, she would have been shot in the forehead from the front. Instead, what happened, what the evidence shows, is that Dustin was grabbing Elwyn's collar with one arm and shooting with the other, while Caitlyn was still confining and restraining Elwyn. It's the only thing that makes sense with all of the physical evidence, that which was presented to you and that which was not, and which was not tested. It's the only thing that makes sense with the location of the gunshot entry wound and exit wound. It's the only thing that makes sense with the trajectory of the bullet down through the drawers. The state's got it wrong when it describes where Dustin was and where Elwyn was when the shot was fired. The evidence that the state presented about what Elwyn says happened also gets it wrong. It's also misleading. The only evidence the state presented about what Elwyn says happened comes from a doctor, not from a police officer or an investigator. Let's go over exactly what Dr. Robertson said. Dr. Robertson was leading Elwyn. She was asking her pointed questions, trying to figure out whether she had any medical issues, based on the only information the doctor had at the time, which was that Dustin shot Caitlyn. Dr. Robertson did the best exam she could with that limited information. Dr. Robertson said that she asked Elwyn if there was anything wrong with her, and at first, Elwyn said no. And only after Dr. Robertson guided her, led her to the answer, did Elwyn eventually say that her ear hurt and pointed to her left ear. Dr. Robertson had to ask her a very specific question to get that answer. She had to ask her how her ear got hurt. And Elwyn answered that question. She said, Mom and Dad were fighting, and Dad hurt Mom and me, and there was a lot of blood. And Elwyn's ear hurt because she had heard a gun that Dustin shot. That's not up for dispute. But think about what Dr. Robertson didn't know to ask. Dr. Robertson asked Elwyn if she was hurt anywhere else on her body, and Elwyn said yes. But Dr. Robertson didn't know what else had happened. She didn't know that Caitlyn had grabbed Elwyn, yanked her, pulled her, twisted her, made her scream in pain. And so the doctor couldn't get the right information out of Elwyn. The doctor didn't know what questions to ask to help Elwyn explain why else her body hurt. Elwyn was just 4 years old, and the doctor, who didn't know everything that had happened, couldn't ask her the right questions to get the full story from her. The state didn't have Elwyn testify. They didn't present testimony of any police officers or investigators who had spoken to Elwyn. They didn't give you the full picture of what Elwyn said. They gave you one small glimpse from a doctor who was there to treat Elwyn, not to interview or investigate. And the doctor didn't know what had happened and didn't know what to ask. You didn't hear the full story of what Elwyn said. The state also presented evidence in a misleading way when it cross-examined Dustin. It tried to suggest that Dustin never told the police that Caitlyn threatened to take the kids. But Dustin told the police over and over again that Caitlyn threatened to take the kids. You have Dustin's statements to police in evidence. And here's the rough timestamps for all the times, not all, but some of the times when he tells the police that she threatened to take the kids away from him, both before the incident and during. 28 minutes and 13 seconds, he says, she just kept threatening, well, okay, I'm going to take the kids away. 28:47, he said, every month it was basically the same thing of her wanting more money with threats of taking the kids away. 31:11, he said, she was basically threatening to put me in prison and take the kids away. 32:39, she threatened to arrest me and take the kids away. He starts discussing the day of the incident. 59:18, she started getting more and more aggressive about how, no, I'm going to take the kids from you. An hour and 16 seconds. The one thing that does set me off is these continued threats of taking the kids away from me. An hour, 1 minute, 58 seconds. Her just again threatening to take the kids and saying she just wasn't gonna leave and that she wasn't gonna leave and that she was going to take Elowen and Valen back to Minnesota. By an hour and 32 minutes into this interview, he said it so many times that the police start talking about how she's threatening to take the kids away. Dustin told the police, and he told you, that she threatened to take the kids away over and over and over again because that's what happened. I've given a lot of timestamps, but I'd ask you to take a listen to the video around 1 hour and 40 minutes. That's when Sergeant McLaughlin asks, and I'm quoting, the training you're talking about is marksmanship training, not specifically hostage? Because that's my first thought, was you're trying to remove Elowen from a harmful situation. Do you have training in hostage type scenarios? That's the investigating officer's first thought, that Dustin was trying to remove Elowen from a harmful situation and wondering if he had training in hostage type scenarios. That was the police officer's first thought, because Dustin was trying to remove Elowen from a harmful situation, from a hostage type scenario. Think about the evidence that the state didn't present to you. The state didn't call Brenda. The state didn't talk to you about or present evidence of testing of the hair stuck in the slide. The state didn't ask the medical examiner about how hair impacts gunshot residue. The state didn't have a police officer who spoke to Elowen testify. The state had Dustin's phone. They had his text messages with Caitlyn, his text messages with Lori, his text messages with Rob, but they didn't show them to you. They didn't want you to hear what they said. Those text messages prove that what Dustin told you is true.
Objection.
Members of the jury, based upon the state of the evidence, I am going to strike the last sentence of the defendant's closing argument and instruct you to disregard it. Thank you.
I expect the state is going to try to argue that Dustin didn't reasonably believe that Caitlyn was committing or about to commit a kidnapping because she was the children's mother and because there was no court order on custody. But that just doesn't make sense. Think about it. Imagine if Caitlyn's secret plan had gone into effect. Dustin would have woken up in the morning to both of his children gone, stolen, kidnapped, taken away to another state. We are talking about unlawfully taking children away from their father to another state permanently without him knowing. We are talking about coming up with a secret plan. We are talking about deception. We are talking about Caitlyn planning to commit a crime. Dustin reasonably believed that Caitlyn was about to commit a kidnapping. And the fact that she's the children's mother doesn't change that. The state's also got it wrong. They're missing the point when they spend hours and days focusing on cell site location data and testimony from someone who saw Dustin's car and presenting a whole lot of evidence of things that aren't in dispute, that Dustin told you happened. They're focusing on what happened after the shot was fired. But what matters in this case is what was happening immediately before and while the shot was fired. This whole case is about Dustin's defense of Elowen. That Dustin was justified under the law. Dustin wanted to spend more time with his girls. That's not a crime. He's not charged with anything related to that. It's only human nature. It's a father wanting to make sure his kids are okay. He wasn't denying what had happened. He called his mom and told her. He knew his dad would call the police. He made sure they knew the girls were okay, and he told them that after he took some time with the girls, he was going to turn himself in. He didn't deny what had happened when he waived his right to remain silent and spoke voluntarily with the police. And he didn't deny what had happened when he took the stand here yesterday and spoke to you. Nothing that happened after the fact changes what happened in that apartment. It doesn't change that Dustin reasonably believed that Caitlyn was about to commit a kidnapping, that Caitlyn had a kidnapping plan, that Dustin was justified under the law. The state is wrong about whether Dustin's use of deadly force was justified. Think about Dustin's perspective. Think about what was going through Dustin's mind at the time. Dustin didn't think there was any help available. Dustin had spent months trying to figure out how to deal with Caitlyn. He called his parents. He called her parents. He called a lawyer in Minnesota and one in Vegas. He called the Berlin Police Department, and they told him they couldn't help. Think about that time a year or two ago when he called the police in Vegas and they didn't show up until after the threat was gone. Think about the fact that Caitlyn had kidnapped his child before and she had a plan to do it again. The judge will instruct you that you should consider how Dustin acted under the circumstances as they were presented to him at the time, and not necessarily as they appeared upon detached reflection. Consider how he felt at the time in that moment that Elowen is screaming in pain. Consider his perspective as a Marine, his perspective as a father whose child had been kidnapped before by the very same person who was holding his child hostage in front of him. And I'd imagine the state is going to talk a whole lot about other things that they think Dustin should have done instead. But think about what's going on here. Dustin tries to de-escalate the situation. He tries to talk to Caitlyn. She won't talk to him. He begs her and pleads with her to just let Elwyn go, and she refuses. He tries to just grab Elwyn, and Caitlyn won't let him. He begs again for Caitlyn to let Elwyn go, and she refuses. He tries to get Elwyn a second time, a third, and the third time he tries even harder, grabbing Caitlyn's wrist with one hand and trying to pull on Elwyn from behind. And it is only once Caitlyn physically harms Elwyn, only when Caitlyn is willing to go to the length of letting her child be harmed, be hurt, to enact her kidnapping plan, that Dustin acts. Even when Dustin grabbed the firearm, even when Caitlyn heard him chamber around, she still didn't let Elwyn go. Even when Dustin pointed the firearm at her, Caitlyn still didn't let go of Elwyn. Caitlyn was still holding Elwyn hostage even after he had taken those steps. Those steps of grabbing the firearm and chambering it weren't enough. So Dustin did what he had to do. Dustin reasonably believed the amount of force he used was necessary because nothing else worked. And again, you will be instructed to think about Dustin's actions under the circumstances as they were presented to him at the time, when he acted in the heat of passion. Consider the stress, the anxiety, the fear, and the need to take immediate action to prevent Elwyn from being hurt, to make sure Elwyn was safe. Your role is not to Monday morning quarterback. It's to think about what Dustin was seeing and thinking and feeling in the midst of this horrific situation when he had to make a split-second decision and act instinctually. And from that perspective, Dustin did what he had to do to save his child. Dustin was justified. Think about the fear that Dustin felt, hearing Caitlyn tell him he was never going to see his children again, seeing Elwyn restrained, confined, held hostage in front of him. And think about the fact that he did not take that action until Elwyn had been harmed, until Elwyn screamed in pain and locked eyes with him, until the line had been crossed. He was a Marine and a father responding to a threat. He was a Marine and a father protecting his beloved daughter. This is a tragedy, but it's not a crime. When you hear from the state, I ask you to keep in mind everything we've just talked about. I ask you to keep in mind that Caitlyn's own aunt told you that Caitlyn had a plan to kidnap the kids. Keep in mind that if Caitlyn had a plan to kidnap the kids, it was reasonable for Dustin to believe that she had a plan, that she was about to kidnap the kids. Keep in mind that the law says that Dustin had the right to use deadly force if he reasonably believed that Caitlyn was committing or about to commit a kidnapping. The judge will instruct you that you must apply the law and that you must hold the state to its burden. When you do, you will return the only fair and just verdict, the only one supported by both the evidence and the law, one declaring Dustin Duren not guilty.
Ready now or whenever you'd like.
Okay, we'll take a break now, mid-morning break now. We'll reconvene at 10:25. Again, please do not discuss any aspect of the case or other evidence amongst yourselves. Please notify a bailiff. If you see anyone do that, we'll be in recess until 10:25. Thank you.
All right.
Okay, thank you. Please be seated. Again, let the record reflect, I'll be moving to adjust my position where I can maintain visual contact. Attorney Duren, you ready to proceed?
Thanks, Ron. Just checking, Your Honor, you're all set?
Yes.
Ladies and gentlemen, this was not an accident. This was not defense of others. This wasn't done to prevent a kidnapping. It was murder. And he knows it. He knows. And that's why he's changed his story over time. He's taken time to craft what he's wanted to say. It's why he has changed what he told the police after he was caught to what he testified to on the stand. It's why he's tried to blame Caitlyn Naffziger for her death. The real victim here, the victim that you're here to decide this case about, is the unarmed woman who the defendant shot in the head, who was sitting on the couch with a child. You know, yesterday, when he testified towards the middle of his cross-examination, he told you in his own words, live from the witness stand, why he shot and killed Caitlyn. And he told you that in that moment, right before he got his gun, right before he pulled the trigger, that she hurt his daughter. His daughter. If you listen to defense counsel's opening, I lost track of the number of times that they described this child as his daughter. Caitlyn Naffziger, according to the defendant, hurt his child. She hurt her by holding her tight, hurt her by pulling her close, hurt her by pulling the child away when the defendant tried to grab her. Turning it on helps. Let's be clear. Caitlyn was holding their child, her child, as much as his. A child she carried for 9 months, a child she gave birth to, a child that she could hold and bear hug and be with just as much as he could. They had equal rights to these children, rights they had been arguing about since August of 2023. On the day that the defendant killed Caitlyn, he was angry. He was yelling. He didn't want to admit that during his testimony, right? I maybe yelled 1 to 2 sentences. The defendant needs to be in control. That is clear from his testimony. It is clear from his statement to the police. He is the person who operates best under stress. He needs to be the leader. He wants to have a plan, and you know what? Once a plan is made, there are no changes. Plans never change. But on that day, on February the 29th of 2024, the defendant was not in control of Caitlyn. You know, defense counsel stood in front of you and said, think about how he felt, that he might have to lose his children, that he couldn't hug them when he was taken into custody. He was asking Caitlyn to drop her child, the youngest one off, their child, with him, to then see her daughter, their daughter, who she hadn't seen in a month and a half, sleep over and leave. Think about that day and what the defendant's behavior must have been. How his frustration over the situation, over the change in plan, turned to anger over the course of a day. It must have. It doesn't make sense that it wouldn't have. He didn't want Caitlyn there in his apartment. He wasn't happy that she had spent the night. It wasn't part of his plan. He wanted her to leave. He testified and told the police that during that day on February the 29th, every 15 minutes or so, I think he said 15 to 30 on the stand, but he said 15 during his statement to police. Every 15 minutes for several hours, up to 5, he agreed with me yesterday, probably between noon and 5 p.m. He went to the room where Caitlyn was playing with their daughters, and he asked her when she was leaving. He hovered in the doorway. Her being there wasn't part of his plan. He wanted the girls with him, and he wanted Caitlyn gone. He told the police that. He told the police that he'd even discussed it with his mother. For at least 5 hours, every 15 to 30 minutes, he went to that doorway and he said, "When are you leaving?" He asked how she was leaving, when is her ride coming? And she was ignoring him. She wasn't ready to leave her children, their children, behind. The defendant was frustrated, but he became angry. He was angry because she wasn't doing what he wanted, wasn't following his plan. He was angry because she was ignoring his questions, because she didn't want to leave. He was angry because they were having the same dispute they'd been having since August of 2023. And Caitlyn, we know, apparently, didn't want to hand their 4-year-old daughter over to the defendant while he was yelling and angry, while he was pulling at the child and trying to yank her from Caitlyn's arms. Caitlyn knew how angry he was, and she knew that he was dangerous. She didn't know how much of a danger in that moment, but he'd show her. You know that Elowen told doctors at the hospital what happened. You know that she asked them to look at her ears because they hurt from the loud noise of the gunshot. Defense counsel wants you to believe that Dr. Robertson, somehow not knowing what happened, led Elowen to make the statement that she made. This simply doesn't make sense. You heard testimony from Dr. Robertson where she explained to you how she approaches a child. "Hi, I'm Dr. Natalie. Can you tell me what hurts?" That's not leading. That's not trying to get an answer from a child. It's trying to find out where they hurt and where to examine. And when Elowen was asked what hurt and where to examine, she said that mommy and daddy were fighting. She said that daddy hurt her and mommy, that mommy had lots of blood. Elowen didn't have any bumps or bruises from being held tight by her mother. She didn't say that mommy hurt her. She said daddy did. The defendant hurt them both, and he hurt them in the worst way possible. On February the 29th of 2024, Dustin Duren murdered Caitlyn Naffziger. He killed her as she sat on a couch in his living room. Remember the testimony. And ladies and gentlemen, you are the deciders of the facts, right? If defense counsel stands in front of you and they tell you something and you disagree with it, that's what you should do as jurors. You're the judges of the fact. If I stand in front of you and I say something that you don't agree was the evidence that you heard, that's what you should do. You should discard what I tell you and pay attention to the facts that you heard in testimony. But the facts that you heard was testimony from Dr. Weinberg, right? And he talked to you about close contact firing. And even under cross-examination, his testimony was that the defendant had to be 3 feet away or more from Caitlyn, and not just the defendant, right? But the tip of the gun. The tip of this gun had to be 3 feet or more away from Caitlyn's body, away from her head when it was fired. And so we know that the defendant stood at a distance when he shot her in the side of her head. When Dustin Duren fired a single bullet from this Beretta 9mm handgun, Caitlyn Naffziger was wrapped up on the sofa in their daughter's pink unicorn blanket. Her foot was on the coffee table. She had no shoes on, and there were none close by. She wasn't threatening anyone. She had no gun, no knife, no weapon of any kind, nothing. She wasn't even looking at the defendant. You know, defense counsel stood in front of you and said, well, if it happened the way the state described, well, then Caitlyn would have been shot in the head. Well, not if she wasn't a threat, not if she wasn't watching him, not if they weren't engaged in any kind of dispute or argument like the defendant has said. We know from the evidence that she was shot here in her temple. That's what the doctor can tell you. In terms of positioning, that's based on how they were interacting at the time, and Caitlyn wasn't looking at Dustin Duren. The defendant's bullet entered the left side of her head at her temple. It traveled straight through her brain. When the bullet exited on the right side of her head, it took pieces of her skull with it. The bullet continued in a straight line, cutting into the built-in bookcase behind her, ricocheting through the drawers. You know, Caitlyn was likely dead before Elowen even saw the blood, before Elowen began screaming about the noise of the gunshot hurting her ears. The defendant didn't check to see if Caitlyn was alive, to see if she could be saved. Instead, he ran. He loaded his car with changes of clothes. More than you needed for one night, more than you need for two. He put his desktop computer tower in the trunk. He turned out the lights, he turned the key in the deadbolt and locked the door. He drove south. He went dark. You know, defense counsel made it a point that you didn't need to know about his phone searches or his phone records. You know what they told you, those records? They told you when he left his house, which gives you an idea of when he killed Caitlyn. Those records that you have in evidence show you that around 6 o'clock, between 5:30 p.m. and 6 p.m., on the 29th of February, the defendant began to leave his home. Caitlyn was dead, and he was on the run. A person who's justified, who acted lawfully, who acted to defend someone, they do not run. They stay in place. They do the right thing. They ended the threat. They call the police and they tell them what has just happened. It's the first thing that they say. They yell it at the top of their lungs. They scream that they had no other choice. But the defendant didn't do that, and he didn't do that because he had choices. There were options that didn't involve putting a bullet through an unarmed woman's head. He knew then that what he had done was not justified. It wasn't in defense of someone else, and it wasn't to stop a kidnapping. It was a murder, and he acted like a murderer. You know, a murderer packs their clothes and drives through the night with two little girls after he has killed their mom and left that mom dead in his living room. A murderer turns off his phone so the police can't find him. A murderer needs 16 hours to tell the police that something happened. And that's how long Dustin Duren had. From 6 p.m. or 5:30 p.m. when he left that house until he was taken into custody at 10:30 the next morning, he had 16 hours. But you know what's even more is a murderer needs 3 hours of background testimony at a trial before he can tell his new version of what happened. A murderer needs a year and a half to explain that his actions were an act of defense of others. You know, ladies and gentlemen of the jury, the defendant thinks in this case that he can fool you, that he can put this claim of defense of others in front of you, and that you will jump on it and detract from his actual actions and his intent. When you were chosen as jurors in this case, each of you individually, you brought your life experience with you. You brought your ability to make assessments and to make judgments, and you brought your common sense. You know, we keep a lot of things that you're not allowed to bring with you into the courthouse or bring with you into the jury deliberation room, but your common sense isn't one of those things. Your common sense and your knowledge about people, it stays with you when you come in the courthouse. It stays with you here in this courtroom, and it will sit with you as you go into that back room to deliberate. Your common sense and your experiences is why you were selected. And it gives you a framework and a basis to evaluate what happened on February the 29th of 2024. This is a framework that you can use to evaluate the witnesses, the testimony, and the evidence. Your common sense plus that evidence and plus the court's instructions are the tools that you have. They're the only ones we give you, but they're the tools that you have to fairly and impartially weigh the evidence in order to determine whether the state has proven beyond a reasonable doubt in this case that the defendant killed Caitlyn Naffziger, and that when he did that, he was not acting in lawful defense of others to prevent a kidnapping when he shot her in the head. You, as I've explained, are also the judges of fact, and that is why you use your common sense to evaluate that testimony. You give the testimony of each witness what you believe it deserves, not what the state tells you and not what the defense tells you. In terms of the first part of your job, determining whether the state has proven beyond a reasonable doubt that the defendant killed Caitlyn Naffziger, at the beginning of this case, we stood in front of you, my colleague, and told you that this is not and would not be a complicated finding for you. This isn't a whodunit, that by the conclusion of the evidence here, you would know beyond a reasonable doubt that the defendant is the person who shot and killed Caitlyn Naffziger. Throughout the past week, you have learned that he confessed to his parents, he confessed to the police, his gun is the murder weapon, that he knows that when you point a gun at a person, you intend on killing, that he knows exactly where the bullet went, and that he has testified now in this case that he is the one who fired the shot. You know beyond a reasonable doubt that he killed Caitlyn Naffziger. The defendant is facing several charges related to this case. Those charges include second-degree murder, reckless conduct with a deadly weapon, and endangering the welfare of a child. The judge has explained some of the law to you, and shortly he's going to explain to you what it means to commit second-degree murder. The defendant, to be clear, is charged with two variations of second-degree murder. He's charged with knowing second-degree murder and reckless second-degree murder. The difference is in what he was thinking at the time that it happened. The court will talk to you about those charges of reckless conduct and endangering the welfare of a child, and those charges, so that you understand, are related specifically to the defendant's actions in which he placed 4-year-old Elowen in danger or violated a duty of care that he had to her. The facts of this case as presented to you over the past week, week and a half, have demonstrated that each of the requirements that you need to find the defendant guilty of these crimes beyond a reasonable doubt have been met. Let's demonstrate what I'm asking, or what the state, what everyone's asking you to do here. I want to look at the factors of second-degree murder. Up on the screen you have in front of you part of what the judge will instruct you on. The judge is the judge of the law, just like you are the judges of the fact. So his instructions will hold, okay? Now you have to decide whether the defendant caused Caitlyn Naffziger's death. Again, this has been proven. The defendant admits that he was the person who pulled the trigger, that he shot Caitlyn in the head. He caused her death. For knowing second-degree murder, you also have to consider whether the defendant acted with a knowing intent to cause her death. That means that when he fired the gun, he was aware that such conduct would cause Caitlyn's death. You should consider all of the evidence that you've heard throughout this case when you decide whether the defendant knew that he would cause Caitlyn's death by shooting her that day. You've heard about the defendant's ability with a gun, his military training. He testified that he raised the gun, and he admitted that the purpose of pointing a gun at someone is to kill. There is no other purpose. He knew that this would be the result when he pointed his gun at Caitlyn and when he pulled the trigger. He knew exactly where the shot would go and the damage that it would cause. For each of the charges that we're talking about, the court, you must also consider the defendant's claim that he was acting in defense of others. Specifically, the judge will instruct you that in this case, acting in defense of others means that the defendant had to not just reasonably believe. Now, defense talked to you in their closing about reasonable. It was a reasonable belief, a reasonable belief. But you'll note that on the screen, and as the judge will advise you later, that there's actually another portion of that. The defendant's belief has to be an actual belief and a reasonable belief. We expect and anticipate that, the defendant testified from the witness stand that all he had about this kidnapping plan or kidnapping idea were his suspicions. Suspicions are not an actual belief, they're just suspicions. The defendant didn't have an actual belief here, and he didn't have a reasonable belief here. And if he didn't have those two things, if his belief wasn't actual, if his belief wasn't reasonable, then he was not lawfully acting in self-defense, and his murder of Caitlyn is not justified. There was a lot of discussion about where Elowin, where the 4-year-old is at the time that the defendant fired. And that's one of the things that you can consider, both in the charges of reckless conduct and with respect to the defendant's claims. At the time that the defendant had fired, if we look specifically at his claim that Caitlyn was kidnapping, right? At the time that the defendant had fired, he had grabbed Elowin with his left hand, and he shot Caitlyn with his right. With that action, the defendant ended any argument he might have made that he had shot Caitlyn to prevent a kidnapping. It was over, it was done, and he had the child. But it's the state's position that there was never any kidnapping. Caitlyn was never about to commit a kidnapping. She was not about to do anything. She had made her position clear to him. She was refusing to leave, and she was seated on the couch holding their daughter. In the defense's opening statement, they told you that the defendant pulled Elowin to safety before he fired. He told the police in his statement that he had grabbed her, pulled her back, and then shot. But yesterday in his testimony, he stated that he had just pulled her forward by her shirt and held her in place. He implies that she was still on Caitlyn's lap when he fires the gun. But the defendant's testimony doesn't fit with the evidence. Dr. Weinberg testified that he found no evidence that the shot occurred within close range. He testified even on cross-examination that his opinion was that it had to be 3 feet or more away. He found no evidence of stippling. Now, this isn't gunshot residue, it's stippling. Little burns of gunshot powder embedded into Caitlyn's skin or face. She didn't have any. There was no stippling on Caitlyn's wound. There was no stippling on her face, her neck, or anywhere on her. Dr. Weinberg found no evidence of soot deposits on her face, and he testified to you that based on his examination of her body, the muzzle of the gun had to be at least 3 feet or more, not closer, 3 feet or further back when it was fired. And if the shot came from 3 feet or more from Caitlyn's body, there is no possibility that Elwyn is on Caitlyn's lap when the defendant fires. Elwyn was in his arms. Even if the defendant had fired the gun in the way that he demonstrated or tried to demonstrate from the witness stand yesterday, he would have been closer to Caitlyn than 3 feet. The gun would have been closer still. Just as he told the police, the defendant grabbed Elwyn and pulled her back. The defendant then had to step back to shoot Caitlyn Naffziger from the distance that her body shows the shooting happened from. Now, I want to talk to you a little bit about defense counsel's desperate efforts with respect to State's Exhibit 24A to talk about a hair on the slide. No one knows whose hair this is. No one. Defense counsel does not have to put on a case. They do not have to bring up evidence. But if this hair was the linchpin that solved it, they had every right and could have. And they chose to put on a case.
Objection, burden shifting.
strike the last sentence from the state's argument. And, two other comments. The defendant had no burden to test any evidence in this case. And in fact, the defendant has no burden to produce any evidence in this matter. So with those instructions, I'll allow the state to continue.
Thank you, Your Honor. Ladies and gentlemen of the jury, defense counsel kept showing you this photograph, the word hair, because there was a hair in the slide. And they want you to somehow put together and believe that that is Caitlyn's hair, because that would somehow show you and prove by their theory that the defendant was closer than 3 feet. That you should use the fact that there's a hair on a gun that was next to the defendant, next to his child, in a pocket inside of a door in a car, and that you should somehow use this missing hair that hasn't been tested to decide that that means he was closer, that you should use this hair to disregard the testimony, the evidence, and the expert opinion of Dr. Weinberg. That doesn't do this. There's no inference as to whose hair. You know, I think we all understand, especially possibly the women on the jury, that hair falls out. It's everywhere. Hair on a gun isn't an inference that you can make. It doesn't matter whose hair it was. None of it would show that Dr. Weinberg's testimony is called into question. Dr. Weinberg, who testifies that this gun, the muzzle of it, the very tip, was at least 3 feet away from Caitlyn when it was fired. 3 feet from here to Caitlyn. You can make reasonable inferences from evidence. You cannot make jumps or wild conclusions. You have State's Exhibit 26B in evidence. That's the defendant's statement. This is an image from that, just showing you him in that room where he was interviewed, in that room with police officers on March the 1st of 2024. He didn't claim during this interview anywhere, at any time, that he acted to defend somebody, that he acted to protect Elwyn from being kidnapped. The defendant didn't shout it at the top of his lungs. He never once said he acted in defense of anyone. Unlike in his prepared testimony Friday of last week and yesterday, the defendant didn't tell the police that Caitlyn was kidnapping anyone or about to kidnap anyone. He also didn't tell the police about his suspicions or make hypothetical statements that someone might be outside of his apartment. He didn't tell the police that she was demanding that he pay her money in that moment. He talked a lot about times she'd asked for money in August of 2023, in September, October, leading up to this incident, but he never said those demands happened before he shot her. He didn't tell the police that she was demanding that he sell his car and give her money. He didn't tell the police that before he shot her in those moments, that he'd never see the kids again. These are all statements that he added over a year and a half later in support of his defense to excuse his murder of Caitlyn. You remember when he was specifically asked in that statement if Caitlyn was threatening anyone or causing any harm, he said no. He never once said he had to act to defend anyone. He never once mentioned a kidnapping. Not until yesterday in this courtroom did he make that statement. And even then, if you remember his testimony, he didn't say that he acted to shoot because his daughter was being kidnapped. He stated that he had shot and killed Caitlyn because in that moment, she was hurting Elwyn. You know, the defense has argued to you that Brenda Plamondon and Caitlyn Naffziger formed some kind of secret plan to take the children. Their plan involved code words. and planned 911 calls. And it never happened because Caitlyn never called. You know, for a plan to be secret, the people involved in it don't tend to broadcast what they're about to do, don't tend to stand in front of the person they're about to steal a child from and say, I'm going to call the police, I'm going to take the kids. You know, about that plan, what defense has termed as a secret plan to go along with the broken promises because Caitlyn wasn't following the defendant's plans. The word plan comes up a lot, and I apologize because it's hard to keep them all straight sometimes. But Caitlyn never called Brenda. She never texted her. She never asked for help. She never sent a code word, and Brenda never called 911. More important to your consideration, defense counsel advised you you're not to Monday morning quarterback the defendant's choices, right? You're only to consider what he knew in that moment. And so if he didn't know that Brenda and Caitlyn had talked about this code word and 911 call plan, then he didn't consider it in the moments before he shot. What you do know is that the defendant didn't know about it and that it never actually happened. And because of those things, because he didn't know, you cannot use it to make the defendant's now stated belief that the defendant was going to kidnap the children become an actual belief or a reasonable belief. You know from his testimony that he only had suspicions. He didn't act on an actual belief, and his belief and his actions were not reasonable. On March the 1st of 2024, 16 hours after he had murdered Caitlyn, the defendant drove from Vermont into Keene. He told you that he was on his way to turn himself into police, to turn himself in for shooting and killing Caitlyn. He drove past multiple police stations in multiple states. He drove past the New Hampshire State Police Barracks at Troop C. He wanted to be arrested on his own terms. He knew that he would be taken into custody. He knew there would be an investigation, and he was ready for that. That's why he came back. He knew that speaking to the police was his opportunity to provide a statement about what had happened, his statement, and he wanted that opportunity. He wanted to speak with police and tell them why he shouldn't be in trouble for what he had done. But he didn't turn himself in. He got taken into custody at gunpoint in front of those two little girls whose mom he had killed. He had 16 hours to think about and prepare for this moment. He had 16 hours to determine what to say, what exactly to say and how to say it. He'd given himself the time and the space to put any spin that he wanted on the events that occurred in his living room. He'd had time to consider what it was he was going to tell police, how he would portray himself, how he would portray Caitlyn. Besides his 4-year-old daughter, there was no one to contradict him. And so he waived his Miranda rights. He spoke with investigators for over 2 hours. They let him talk about anything he wanted to address and just asked him questions to fill in the blanks. This was the defendant's opportunity to tell them why he had killed Caitlyn. He said she refused to leave. He said she was bear hugging their daughter, that she wouldn't let go, that he tried to pull the child away. If you listen in the tape, there's about 40 minutes where he talks about their background and his disputes with her and their custody issues. It's not until almost an hour in that he actually starts talking about the moment that Caitlyn was in his apartment and leading up to his killing of her. In those moments, at around, I believe it's 1 hour and 4 minutes, the defendant says he was trying to grab Elowen and be like, hey, let go of Elowen, and she just wouldn't do it. And that was kind of the tick. And then he says, I think the moment was definitely very deliberate and fast. it was like the line had been crossed. That her not letting go, her continuing to hold Elwyn, was the only thing, the tick, the moment in his mind when he decided to kill, the moment when he decided to walk for his gun. And you know that he decided to kill in that moment because he did grab his gun. He racked the slide. He switched the safety off, and he walked over to shoot Caitlyn. And you know that Caitlyn saw him as he picked up that gun, because he told you in his testimony, she was closer to it than he was. And you know because you heard that gun as it racked when Jill Terrio was showing it to you. You know Caitlyn heard the racking of that slide. And for what the defendant would admit to in his testimony yesterday, she at least tried to ask him what he was going to do with it. But he didn't answer, because within seconds, he had shot her in the head, and Caitlyn was dead on the sofa. The defendant shot and killed her without a second thought, and he never, not one time, said anything about Caitlyn being a threat or a danger to anyone in that moment, not until he took the stand yesterday. Compare that to his actions as he described them in that story about the burglar in Nevada, a story that defense puts to you in their closing as explaining why he didn't call the police when Caitlyn was in his house. But it does so much more than that. It shows you the difference in behavior that the defendant has, the restraint that he can show, the fact that his muscle memory isn't all that's to him. A stranger trying to break into his home received more consideration than the mother of his children. That stranger was told to leave. He told them to go. He called the police. The defendant warned the stranger that he was armed with a gun. He went to the length to open the door and show the stranger the gun. He sat and waited with his loaded gun while the stranger tried the door, tried the windows, tried to break in. His muscle memory didn't take over. He didn't just shoot. The defendant never fired. He didn't shoot. The stranger walked away unharmed. But the mother of his children, she had to die. You listened to his statement during the presentation of the case. You have it in evidence, and you can listen to it again as many times as you want. You'll have a laptop back there that hopefully has a working CD player. You can listen to it, you can rewind it, you can jump to spots you want to hear. You should watch it. You should compare it to the statements that the defendant has now given to you from the witness stand. When you watch it, watch his demeanor, his body language, his facial expressions. Listen to the places where he hesitates or doesn't really answer the question that he's asked. Listen to the places where he scoffs, laughs, or smiles as he provides information to the police about where the bullet struck the mother of his children. Listen to the information he gave the police and his reactions and behavior when this was still fresh in his mind, 16 hours later, when he hadn't reviewed any evidence against him, but instead was telling things as they had happened. Even then, much like the defendant spent 3 hours sitting on this witness stand talking about child custody and his life before children, as well as his love of his children, the defendant spent the first 40 minutes of that interview talking about those same things. Again, the defendant begins discussing the shooting about 40 minutes in and the reasoning for it about an hour in. He says that she was holding Elwyn and refusing to leave. That's it, nothing else. Nowhere in the statement does he say that he acted because Caitlyn was using force to commit any crime, let alone a kidnapping or being about to commit a kidnapping. Nowhere in that statement does he say she was harming anyone or physically threatening anyone. Many of the statements that he made yesterday are not in the statement to police. He never told the police that that night Caitlyn again demanded money from him or to sell his car. He never told the police that he was concerned that Caitlyn could reach for a gun. He never told the police that Caitlyn put her foot on the table and tried to use that to push away from him. He never told the police that Elowen shrieked or yelled or cried out because she was being hurt. He never told the police that he taught Caitlyn to fire that gun. You know, the defendant told you that during his testimony that he wanted you to believe that he's adding this information because he was misunderstood. He wasn't misunderstood. His words weren't misinterpreted. He just never said these things, not for a year and a half. He is adding these things to change your opinion of him and of his actions, to try to get away with murder. The defendant spoke with detectives about every bad thing he believes that Caitlyn Naffziger had ever done to him or concerning their children. Is there any doubt in your minds that if she had said all these things he added from the witness stand, that he wouldn't have included them for the police? He'd had 16 hours to figure out to portray her as the villain and himself as the victim. The defendant has testified about being a Marine and being a father. Both of these things are true. But a third thing is true. He murdered Caitlyn Naffziger. He killed her out of anger, anger that she was questioning his plans, anger that she was remaining in his house and wasn't leaving like his plan said she would. You got to hear those 3 hours of testimony in which the defendant spoke about his history and his love of his children. You'll never hear Caitlyn Naffziger's history, or about her love of being a mom, about her love for those same children, children she carried to term, her memories of their first years. You won't hear about Elowen's first Christmas when she was just 2 weeks old. All you got to hear was when Brenda Plamondon told you that Caitlyn was so loving and so happy to be a mom. You don't get to hear Caitlyn's story about those last moments of her life. She isn't here because the defendant killed her. The defendant killed her out of anger. He killed her because he wasn't going to lose power over her, he couldn't control her, and he wasn't going to swallow his pride again. The defendant is bigger and stronger and heavier than Caitlyn Naffziger. He talked with detectives about whether she'd ever been violent with him, and he told them he would never have registered it because she was so tiny. She couldn't hurt him if she tried. Not then, not ever. And one thing the defendant never said, not once, not during any statements with the police and not from the witness stand, is that Caitlyn never, ever hurt their children. There's no evidence that he even would try to say that. Now, the defendant wants you to believe that he shot this small, unarmed woman in defense of others, that this murder was justified, that he had no choice, that his use of force was somehow proportional, because the judge will explain to you that his use of force has to be proportionate to what he is responding to. The defendant wants you to believe that what he did was reasonable. He wants you to find that Caitlyn was committing or about to commit a kidnapping when he killed her, that she posed a danger when he killed her, and that this makes his killing valid, that he was right to shoot her in the head. All of this despite his clear testimony that he had shot and killed her just because she had hurt their child in the moment before the shot rang out. In order for you to find the defendant not guilty in this case, you would have to find that he acted in defense of others, that he both actually and reasonably believed that the mother of his children was committing a kidnapping or attempting to commit a kidnapping in that moment. Again, the defendant himself testified that he had suspicions, but you cannot kill someone over suspicions. It's not an actual belief, and it is not reasonable. The defendant testified that Caitlyn was threatening to call the police, that she threatened to take the children, but you cannot kill someone over a threat. That is not reasonable and is not an actual belief. There is nothing in the defendant's statements to police or even his testimony that demonstrates that deadly force was necessary or proportionate to the reason that he said he fired. He was a Marine. He was trained in martial arts. She was unarmed. The defendant didn't use deadly force because he had no other choice. He shot an unarmed woman in the head. He murdered Caitlyn. You have an evidence, State's Exhibit 9A. So just blown up for the purpose of presentation. State's Exhibit 9A shows you Caitlyn as the defendant left her in that living room. This is a photograph of a mother sitting snuggled under blankets on a sofa, who has one foot kicked up on a coffee table, who has no shoes, no weapons, and poses no danger. This is a woman who moments earlier had a child on her lap, their child, their child. This is not a woman who was committing or about to commit a kidnapping when she was shot in the head. This is a woman with no friends in Berlin, New Hampshire, no friends in the area. Her family, a 2.5-hour drive away. She had never been there before. She had no car, no bus ticket, no means to leave. The defendant's reasons for shooting Caitlyn had nothing to do with the kidnapping. He told you he shot and killed her because he believed that Elowen was being hurt. He described that Elowen was hurt during his efforts to take her from Caitlyn. He said Caitlyn hurt her by holding her too forcefully. A person cannot use deadly force to protect someone from being held too tightly by their mother. That's not reasonable. The defendant did not have an actual or a reasonable belief that Caitlyn was kidnapping or about to kidnap these children. There's no justification, no excuse. This is not a reasonable use of deadly force. The facts tell you that. The law tells you that. Your common sense tells you that. The defendant shot this unarmed woman in the head while she was sitting on a couch, wrapped in a pink unicorn blanket. He shot her because she refused to leave and was holding their daughter. This wasn't an accident. It wasn't self-defense. It wasn't to prevent a kidnapping. It was murder, and he knows it. And now, so do you. The time for excuses is over. Please find him guilty of all of these charges.
Okay, members of the jury, we're at the point where I am now going to provide my instructions to you. Once again, I do think under the circumstances of this case, I do think it's appropriate to take a brief break before I provide you with my instructions. So we'll be back at 11:35. You'll hear my instructions. After that, you will be ready to deliberate. And until then, again, until you have my instructions, I instruct you not to discuss the case with anyone amongst yourselves. And if anyone does so, please report that to a bailiff. As soon as we're back, I'll complete my instructions to you, and at that point, you can deliberate. Thank you. Please rise for your all rise.
presiding. Please remain standing for the honorable jury.
Okay, thank you. Please be seated. Members of the jury, at the beginning of the trial, I gave you some general instructions as to the law that applies to this case in order to give you some guidance as you considered the evidence in this case. We are now at the end of the case, so I will give you further instructions, and then you will retire to the jury deliberation room to decide your verdict. You will receive a written copy of these instructions when you are ready to deliberate. I am going to repeat the instructions that I gave you at the outset because this trial has occurred over several days. Place no special emphasis on any of the instructions that I am repeating. I am repeating them only to remind you of my earlier instructions in the interest of being complete. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before you reach your verdict, and you have to understand what to consider in deciding whether to believe a particular witness. These instructions, as I said, will explain the law as to these and other matters so that you can reach a fair and just verdict. It is up to you to decide the facts of the case. You and you alone are the judges of the facts. You must decide the facts solely from the evidence in this trial. You apply the facts as you find them to be to the law as I give it to you in these instructions, and in this way you reach your verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You are to decide the facts based only on the evidence, and the evidence in this case consists of the testimony under oath of the witnesses and any exhibits which have been admitted into evidence. Those exhibits will go with you into the jury deliberation room. There are certain other matters that you may not consider as evidence. The fact that the defendant has been arrested and charged with a crime is not evidence of his guilt. In this case, the defendant was charged by means of a document called an indictment. An indictment is simply a way of giving the defendant notice of the accusations against him. This type of document is a formal way of accusing him of a crime in order to bring him to trial. In your deliberations, you must not consider the fact of the defendant's arrest, the indictment, or the fact that the defendant has been brought to stand trial as evidence of the defendant's guilt. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge, and you should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. What the lawyers have said to you is not evidence. In their opening statements and their closing arguments, the lawyers discussed their view of the facts to help you understand the evidence from their point of view. But the lawyers are not witnesses in this matter, and therefore they cannot testify. Therefore, what they said to you is not evidence in the case. If the lawyers stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Also, if the lawyers stated the law differently from the law as I explain it to you in these instructions, then you must disregard what the lawyers have said about the law and follow my instructions. During the trial, the lawyers made objections. Lawyers are supposed to object when they believe that certain evidence may not be admissible under our rules of evidence. Please do not hold it against either party if they made these objections, and sometimes these objections required bench conferences. If I sustained an objection and I excluded any evidence, you must not guess as to what the evidence might have been. If I ordered that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overruled an objection and I admitted certain evidence, then you must not give that evidence any special weight as a result of my ruling. I am not expressing views as to the importance of evidence when I make my rulings. I am merely applying the law, as is my duty. Throughout the trial, I must be fair and impartial, just as you are required to be. So if I said or did anything during the trial that causes you to believe that I favor one party over the other, I now instruct you that I do not favor either party in this case. The role of the judge is to run the trial in a fair and orderly manner, to decide the admissibility of evidence, and to instruct you, the jury, on the law that applies to the case. You, and you alone, as I said, are the judges of the facts, and you decide the verdict. Beyond explaining what you must not consider, I'm going to describe what you can consider as evidence. You should consider the testimony of witnesses and any exhibits that may have been introduced as evidence. In other words, you should consider only the legally admissible evidence and reasonable inferences that you can draw from the evidence. By reasonable inferences, I mean conclusions which reason and common sense lead you to draw from the facts that are proven to your satisfaction. There are two ways for a party to prove a particular fact in the case, either through direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. In other words, circumstantial evidence is proof of a chain of facts and inferences that tend to prove whether the defendant is guilty or not guilty. Let me give you a brief example to demonstrate the difference between direct and circumstantial evidence. Assume that when you enter the courthouse, it is cloudy outside. While you are in court, you see someone come into the building who is wearing rain boots, the person is soaking wet, and they are closing an umbrella. If you could actually look out the window and see for yourself that there is rain falling from the sky, that would be direct evidence that it is raining outside. In contrast, if you cannot see for yourself whether it is raining outside, you could consider the facts and circumstances of the person you observed entering the court with the rain boots and umbrella to determine whether it is raining outside. That is an example of circumstantial evidence. You should consider both types of evidence, direct and circumstantial evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct or circumstantial. There is, however, a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of a charged offense, then in order to convict, you must find that the totality of the evidence as to those elements excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, I skipped a line. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you must decide which witness to believe. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, must decide which witness to believe and whether, based upon all of the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. Similarly, if only one witness provides direct evidence concerning an offense charged, then you must decide whether to believe that particular witness, considering the factors I have already outlined and any other considerations you would ordinarily use in deciding whether to believe a person based on your common sense and good judgment. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or the quantity of the evidence that is important, but the quality of the evidence. That is, how persuasive the evidence is to you. In summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's appearance, attitude, and behavior on the stand and the way the witness testified, the witness's age, intelligence, and experience, the witness's opportunity and ability to see or hear the things about which the witness testified, the accuracy of the witness's memory, any motive of the witness not to tell the truth, any interest that a witness had in the outcome of the case, any bias of the witness or friendship or animosity the witness may have for or against any of the other people in the case, the consistency or inconsistency of the witness's testimony, whether or not what the witness said appears reasonable or unreasonable, whether what the witness said is consistent or inconsistent with the testimony of other witnesses or with statements the witness made at another time. In deciding which witnesses to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted. Nor are you required to accept testimony as true simply because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. The principles I've outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss how convinced one way or the other you must be, and this is referred to as the burden of proof. Under both our state and federal constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt rests entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent man, and you must consider him to be an innocent man until the state convinces you beyond a reasonable doubt that he is guilty. If, after all the evidence and arguments, you have a reasonable doubt as to whether the defendant committed any one or more elements of the offense, then you must find him not guilty. Ladies and gentlemen, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this: if you have a reasonable doubt as to whether the state has proven any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. Members of the jury, you must consider all of the instructions I give you, regardless of any opinion you may have as to what the law ought to be. The law, as I explain it to you, is the law you must follow in reaching your verdict in this case. Remember, all of the instructions I have given you throughout the case should be considered as a whole. So do not single out any particular instruction for special emphasis. As I told you at the outset, you will have a complete written copy of these instructions to have with you in the deliberation room. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts: one, a criminal state of mind, and two, an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what his state of mind was. The phrase state of mind refers to what a person mentally believes his physical acts will accomplish. The word act refers to a physical deed. Thus, for a person to be guilty of a crime, he must have done the following two things. First, he must have had the required state of mind, and second, he must have physically acted to do something that is criminal. Unless a person both had the required mental state and acted to do something criminal, that person has not committed a crime. This means that if a person either did not have the required mental state, or if a person did not physically act to do something criminal, then he is not guilty of a crime. Remember that the reason crimes are given different names is that each refers to either a different mental state, or a different act, or a different mental state and a different act. Many persons do not realize that sometimes the only reason two identical acts are given different names is that they refer to different mental states. For example, let us assume that two drivers of automobiles hit someone crossing a street. If one of the drivers intended to hit the pedestrian, whereas the other one did so out of carelessness, they would not be guilty of the same crime because they had different mental states. Thus, you can see how both the act and the mental state can make a difference. I am now going to discuss the definitions of the crimes with which the defendant has been charged. At the beginning of the trial, you heard the clerk read the charges against the defendant. You will receive copies of each of these charges with you in the deliberation room. In Charge ID 223-7508C, the defendant is charged with the crime of second-degree murder. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, and 2, the defendant acted knowingly, and 3, the defendant did not act in defense of another. These are the elements of the crime of second-degree murder, knowing. Certain words in the definition need to be defined. A person acts knowingly when he is aware of the nature of his conduct or the circumstance under which he acted. The state does not have to prove that the defendant specifically desired or intended a particular result. What the state must prove is that the defendant was aware of the nature of his conduct or the circumstance under which he engaged in the conduct. Whether the defendant acted knowingly is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proved that the defendant acted knowingly. Evidence has been presented that the defendant acted in defense of another with respect to this charge. When there is some evidence of defense of another, the state must prove beyond a reasonable doubt that the defendant did not act in defense of another. If you have a reasonable doubt on any of the charges as to whether the defendant acted in defense of another, you must find the defendant not guilty as to that charge. In deciding whether the defendant acted in defense of another, you should consider all the circumstances surrounding the incident. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. A person has the right to use deadly force on another person to defend a third person if, 1, he actually believed that the other person was committing or was about to commit the crime of kidnapping, and 2, even if the defendant actually believed that the other person was committing or was about to commit the crime of kidnapping, the defendant's belief must be reasonable. In other words, there must be reasonable grounds for the defendant to have believed at the time that the other person was committing or was about to commit the crime of kidnapping. The distinction between deadly and non-deadly force depends on the defendant's mental state. If the defendant had the purpose to cause death or serious bodily injury, or if the defendant knew he was creating a substantial risk of causing death or serious bodily injury, then you should find that the defendant used deadly force. Serious bodily injury means harm to the body which causes severe, permanent, or protracted loss of or impairment to the health or function of any part of the body. If you find that the defendant purposely fired a firearm capable of causing serious bodily injury or death in the direction of another person, then you should find that the defendant used deadly force. Any other assault, confinement, or other action by the defendant is non-deadly force. Thus, if the defendant did not act with the purpose to cause death or serious bodily injury, and the defendant did not know he was creating a substantial risk of causing death or serious bodily injury, then you should find that the defendant used non-deadly force. The defendant must reasonably believe that the amount of force that he used was necessary for defense of another. A person is not permitted to use excessive force in defense of another, only a reasonable amount of force. The defendant can use the amount of force which he believed was necessary under the circumstances as long as, at the time, there were reasonable grounds for his belief. In Charge ID 221-7221C, the defendant is charged with a different variant of the crime of second-degree murder. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, and 2, the defendant acted recklessly under circumstances showing an extreme indifference to the value of human life, and 3, the defendant did not act in defense of another. These are the elements of the crime of second-degree murder, reckless. Certain words in the definition need to be defined. The term recklessly refers to the defendant's mental state. To prove second-degree murder reckless, the state must prove that the defendant acted recklessly under circumstances showing an extreme indifference to the value of human life. A person acts recklessly when he or she is aware of and consciously disregards a substantial and unjustifiable risk that his or her conduct would cause a certain result. The risk must be of such a nature and degree that, considering the circumstances known to him, its disregard constitutes a gross deviation from that conduct that a law-abiding person would observe in the situation. There are several components of a reckless mental state that the state must prove on this variant. They are: 1, the defendant was aware of a substantial and unjustifiable risk that his conduct would cause a particular result, and 2, the defendant consciously disregarded the risk. In other words, he elected to disregard the risk and take the chance that his conduct would cause a particular result. It is not enough for the state to prove that the defendant failed to become aware of the risk involved. The state must prove that the defendant was aware of the risk and consciously disregarded it. And 3, from what the defendant knew of his circumstances, his disregard of the risk was a gross deviation from what a law-abiding person would have done under the circumstances. The key words here are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from what a law-abiding person would have done under the same circumstances. For a killing to be second-degree murder, the defendant must not simply act recklessly, but rather must act recklessly under circumstances showing an extreme indifference to the value of human life. This means something more than being merely aware of and consciously disregarding a substantial and unjustifiable risk of death. The risk involved and the disregard must be so blatant as to manifest extreme indifference to the value of human life. With regard to element 3, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition above. In Charge ID 221-7222C, the defendant is charged with the crime of reckless conduct with a deadly weapon. The definition of the crime of reckless conduct has 5 parts. The state must prove each part of the definitions beyond a reasonable doubt. Thus, the state must prove that 1, the defendant engaged in conduct that either placed or may have placed another person in danger of serious bodily injury, and 2, the defendant acted recklessly, 3, the defendant used a deadly weapon, and 4, the deadly weapon was a firearm, and 5, the defendant did not act in defense of another. Certain of these terms must be defined. Serious bodily injury means any harm to the body which causes severe, permanent, or protracted loss of or impairment to the health or of the function of any part of the body. The term recklessly has the same meaning as that set forth above. Deadly weapon means any firearm, knife, or other substance or thing which, in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. A firearm is not necessarily a deadly weapon. whether the specific manner in which the defendant used the firearm and the circumstances surrounding that use rendered the firearm a deadly weapon is a factual issue for you to decide. With regard to element 5, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition as above. In Charge ID 221-7223C, the defendant is charged with the crime of endangering the welfare of a child. The definition of this crime has 5 parts. The state must prove each part of the definition beyond a reasonable doubt. Thus, the state must prove 1, the defendant owed a duty of care, protection, or support to a child under 18 years of age, and 2, the defendant purposely violated that duty, and 3, in doing so, the defendant's action endangered the welfare of the child, and 4, the defendant acted knowingly with respect to the endangerment, and 5, the defendant did not act in defense of another. Certain of these terms must be defined or explained. The term purposely means that the state must prove that the defendant had the conscious object to do certain acts or to achieve a certain result with respect to the duty that he owed to the child. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means that the defendant desired to cause a certain result or to do the prohibited acts. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do the particular acts. Whether the defendant acted purposely is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted purposely. Your determination as to whether the defendant acted purposely is with respect to the action he took relative to his duty of care, protection, or support, and not with respect to the effect of such action. The term welfare means general well-being in any respect. Endangerment means the act or an instance of putting someone or something in danger or exposure to peril or harm. To find endangerment, the state must prove that the defendant engaged in behavior creating an actual and significant risk of injury to the child's welfare. The term knowingly has the same meaning as that set forth above. Your determination as to whether the defendant acted knowingly is with respect to the effect of the actions he took toward the welfare of a child. With regard to element 5, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition above. Each of the charges against this defendant constitutes a separate offense. You must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on any one of the charges should not influence your verdict with respect to the other charges. In this case, the defendant is charged with 2 separate counts of second-degree murder. One indictment charges the defendant with second-degree murder under a theory of a knowing mental state, and the other indictment charges the defendant with second-degree murder under a theory of a reckless mental state. These indictments are presented on alternative theories of culpability. You will deliberate and reach a verdict on each indictment. You should evaluate all of the evidence and apply that evidence to each indictment. The fact that you may find the defendant guilty or not guilty on one indictment should not influence your verdict on the other indictment. The principles I've outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, expert witnesses, medical personnel, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Beyond witness testimony, you will also be provided with certain exhibits that were introduced by the parties and allowed by the court into evidence. The court notes that some of the exhibits are considered tangible or physical exhibits, specifically including a firearm that was introduced into evidence. A lock has been affixed to the firearm to ensure your safety. If you would like to examine either the firearm or the ammunition, please notify the bailiff and those exhibits will be brought to you. However, you will not be allowed to examine the firearm and the ammunition at the same time. Further, although you are allowed and encouraged to view and inspect these items, please take no action with respect to these exhibits or any of the other exhibits for that matter, which would in any way impair their ongoing use by the court as items of evidence. Members of the jury, the principles of law that I've given to you are intended to guide you in reaching a fair result in this case, which is important to both of the parties in the courtroom and to the court. You are to exercise your judgment and your common sense, as I said before, without passion, without prejudice, and without sympathy, but with honesty, understanding, and due deliberation. When you have considered and weighed all of the evidence, you must make findings with respect to the charges that are before you. You must decide if the state has proven each of the elements of each of the charges beyond a reasonable doubt. In other words, if you have a reasonable doubt as to whether the state has proven any one or more of the elements of each of the offenses charged, you must find the defendant not guilty as to that charge. However, if you find that the state has proven all of the elements of any of the offenses charged beyond a reasonable doubt, then you should find the defendant guilty as to those charges. Let me remind you that a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each and every juror agree with the verdict. In other words, your verdict must be unanimous. All 12 jurors must agree that the state has proven each element of each of the charges beyond a reasonable doubt as to that charge. You may find the defendant guilty on one, more than one, all, or none of the charges. When you have arrived at your verdict, let the bailiff know and you will be returned to the courtroom where the foreperson will render that verdict orally in response to questions that the clerk of court will ask you. The foreperson should see to it that the jury takes up the issues that are before you. He or she should see to it that each juror has a full, fair, and adequate opportunity to present his or her views, positions, and arguments with respect to the law and the evidence. As your first order of business, you shall decide upon your foreperson, write the foreperson's name on a piece of paper, and notify the bailiff of your choice by handing the paper to the bailiff. Ladies and gentlemen, this case is important to both of the parties, the state and the defendant. In your deliberations, you should follow these instructions which the court has given you. You should make a conscientious effort to determine what a fair and just result is in this case, because that is your highest duty as officers of this court. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement. If you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or merely for the purposes of returning a verdict. If any question of law should arise during your deliberations, the foreperson should write that question out, sign it, hand it to the bailiff, and the question will be brought to me, and I will return it to you with an answer. If, however, your question is one of fact, then I will not be able to help you because, as I told you before, you and you alone are the sole judges of the facts, and therefore you must rely upon your collective memory to resolve a factual dispute. A verdict form has been prepared for your convenience, which contains spaces for you to check off whether you find the defendant guilty or not guilty on each of the charges. Once you have finished your deliberations, the foreperson will complete the verdict form, sign it where indicated, and then notify the court officer who will give the form to me. After I review it, I will return it to the foreperson, and you will return to the courtroom where, in response to inquiry by the clerk, the foreperson will announce your verdict here in open court. Thank you for your attention. I will now select 4 alternates. Members of the jury, under state law, we provide for alternates beyond the 12 required to deliberate in the event that something occurs during the course of the trial. And I will give further instructions about the alternates once I pick them, but that is the process we are about to undertake. Council, I have prepared the appropriate number of cubes, and I'm going to shake the cube, shake the jar. I'm going to not look at it, and I will select one, then I will repeat that process. Any objection to that process, Council?
No, Your Honor.
Okay. Juror number 1. Juror number 4. Juror number 2. And juror number 5. The alternate jurors are still members of the panel, even though they will not be deliberating at this time. Because it may be necessary for the alternates to rejoin the deliberations, I instruct the alternates that while you remain segregated from the deliberating jurors, you are not to discuss the case with anyone, including amongst yourselves. When the jury reaches a verdict, you will be returned to the courtroom to hear the verdict. I want to thank the alternates for your service, and in a moment when we recess, I would like to see the alternates briefly at the bench. The jury may now retire to the jury deliberation room. It will take a few minutes, but I will see to it that the evidence and a copy of these instructions are brought to you. Anything further, counsel?
Could we approach, Your Honor, briefly?
The jury may retire to the deliberation room, and I will see the alternates at the bench, please. Thank you.
All right.
I have no further questions of the witness, thank you.
All right, any redirect?
Yes, Your Honor. Mr. Sims, there was a question posed to you as to whether Dr. Parker was focused on her duties and responsibilities. Do you recall that?
Yes.
And we've already talked about, and this is already in evidence, as Plaintiff's Exhibit 22, permission to publish, Your Honor.
You may, yeah, go ahead, Sean.
This is page 14 of Exhibit 22. This is the crisis management protocol. And do you see that front, that very top portion of this?
Yes.
And it talks about a responsibility of a school administrator. Is that right?
Yes.
What does it say?
The first one,
Yes, the first one that I've starred.
the school administrator shall take appropriate action to ensure safety of the students and staff.
And back in January of 2023, there was also a staff handbook at Rich Neck Elementary School. True?
Yes.
Your Honor, objecting the stage judge.
All right, is this a document we've discussed previously in the motions?
No, we have not, Your Honor. I think we need a sidebar, or we need to have the jury excused for this argument.
All right, and what's the title of the document again?
This is Rich Neck Elementary School 2022-2023 Staff Handbook, Mrs. Brianna Principal, Dr. Ebony Parker, Assistant Principal, updated August 15th, 2022.
Has it been given an exhibit number?
Exhibit number 108.
All right, and not previously handled in motions day? Is that
Not specifically addressed.
Okay. All right, and so what is your objection?
It was produced after motions day. It arrived last week for the first time, Your Honor. We had never seen this before. Never been produced in discovery, was not relied on by any expert, and showed up last week in two phases. One, someone had taken a screenshot, and then in a second, the full copy. And we objected that day on our supplemental objections to the witness and exhibit list.
All right. So you're arguing that that is it was produced late in the discovery process in violation of an order, is that correct?
It was in violation of the rules of discovery, and it was also beyond the court's mandated time to disclose witnesses and exhibits.
Okay. All right. Mr. Benioff.
Your Honor, we received this exhibit late. We shouldn't have, and that's because it was requested from Dr. Parker during the course of discovery and not produced. And we had to obtain it through a third-party source. We obtained it past the deadline, and we disclosed it promptly. And now at this stage, we, based upon the line of questioning that was provided, we either intend to refresh the witness's recollection if he doesn't recall the handbook, or we intend to specifically introduce it into evidence if accepted by this court.
All right. So you're not moving it at this point. You are just crossing, well, you're directing, you're actually on direct now. So I'm going to overrule the objection, allow him to direct on the handbook.
May I add something to the record, Your Honor?
Sure.
With respect to Mr. Benioff's statement that it was requested in discovery, as all discovery was objected to on the basis of the Fifth Amendment, on any questions related to handbooks. Mr. Benioff, the plaintiff, never moved to overrule the objection based on the Fifth, and to come in here now and say that we somehow did not produce something is not fair.
Okay. Overruled. Go ahead.
May I proceed, Your Honor?
You may.
Permission to approach the witness?
Yes.
Mr. Sims, I'm handing you the document, or I guess I just handed you a document that says Rich Neck Elementary School 2022-2023 Staff Handbook. Do you see that?
Yes.
Was this the...
All right, we'll get a break, but first let's bring in our guest for the hour in Los Angeles, criminal defense attorney Marie Pereira. Well, you're shaking your head. All right.
Already.
Lay it on us. What are your thoughts?
Oh,
Feels
we
like
got to
a
be able to
mute
hear
button.
those thoughts, Marie.
I'm reading
Check that mute
her
button
lip.
real quick for us.
I think Marie just said something about a sneaky link, or no, I don't know. Is your mute button on, Marie? We're not hearing you.
Sorry. I'm so sorry. I was just thinking the alleged shooter was 6 years old. He should have been coloring instead of carrying a gun. It's shocking to me that we're here to argue about, is the school responsible and the teacher for him bringing a gun to school, and that he actually shot the teacher through her hand, in her chest, and collapsed her lung. This is where we're living right now. It's shocking to me that we're here talking about this, a 6-year-old.
Is the fact that it is so shocking the reason perhaps that we are seeing not only these civil allegations, but we also have criminal charges against this principal? I mean, I'm thinking about the different cases that we've seen of late where a parent has been held responsible, or in the Crumbly case, Ethan Crumbly, where we also have had school resource officers who have been found liable when it comes to whether or not they acted when someone shoots or it's school shooter. So we've got a 6-year-old now. Is this what we can expect because we don't want things like this to happen?
I think, yes, this is a trend that we're seeing. We're holding adults responsible for the acts of children that could have been prevented and were foreseeable. But in this situation, I think it would be extreme to blame the teacher. I believe the mother of the child pled guilty to some sort of negligence and she was punished. But to say that this teacher, because she was in charge, should be held criminally liable, I think is extreme. Maybe civilly, because obviously there was a duty and there was a breach of that duty and there's causation and there were injuries. But the foreseeability here is the problem. Was it foreseeable that a 6-year-old who should be, like I said, coloring a book would come into the school carrying a loaded weapon? That part is going to be really tough for the jurors to decide. Is she really responsible for what happened to that teacher?
Yeah, and of course, this is the civil prong of this that we're watching play out in that Virginia courtroom, and the the criminal aspect of this is in a whole different venue. But yeah, I mean, I agree on some level. Maria was like, all right, she's the assistant principal of an elementary school. Of all the things you're thinking about, and Julia and I were talking about this a little bit during the break, it's, do the kids have their juice boxes, and did somebody get away? Are there, it's not, I don't know that you got your guard up for a kid with a gun. It's so off the wall, and you wonder to what extent her responsibility was. She's doing her job. Maybe she wasn't doing it great that day, but...
And the defense is leaning into that, saying hindsight is 20/20, and that she could not have known from her perspective that this would happen. I think that's what makes it so shocking. Marie, stand by. We've got to get to a break, but when we come back, we're going to talk more about this case. We'll get you back in for more of the testimony. Plus, you may have noticed on your screen, we've got the verdict clock up. Verdict Watch has started in New Hampshire. Court TV's Kelly Craft is going to join us for an update on the Amber Alert murder trial for Dustin Duren, who took the stand in his own defense. Will it sway a jury? We'll be back.
I don't think so. Welcome back to Court TV Live, along with Julia Janae and Ted Rollins. We're going to check in New Hampshire, where you see the clock ticking on your screen. Jury deliberations are underway in the Amber Alert murder trial for Dustin Duren.
And you'll remember Duren. He's the one who took the stand in his own defense, accused of fatally shooting the mother of his children, Caitlyn Naffziger. This happened at their apartment. He pulled his daughter away from Caitlyn, fired one shot, killing her, and then fled the scene with their 2 kids. And he took the stand to say he did it all in self-defense. He's a Marine veteran, suffers from PTSD, and that was his claim, that she was threatening to kidnap his children. Joining us now with the latest is Court TV legal correspondent Kelly Craft. What's an update on where we stand inside of that New Hampshire courtroom?
Well, hi there, Julia and Ted. So they just got the case a short time ago, only 14 minutes in. I cannot imagine in this particular case they are going to be out too long, but you never know. So this morning, we had the closing arguments in this case. What did the state say? Started off right away saying, this is murder, and the defendant knows it. He went and shot an unarmed woman who was holding their child. So the state extremely clear, saying this was murder. Defense counsel, however, saying this is self-defense and that under the law, he had the right to do what he did, which is use deadly force to kill someone who was holding their child hostage and about to kidnap that child. Let's go ahead and listen to some of the closing arguments.
The law says a person has the right to use deadly force when they reasonably believe that someone is committing or about to commit a kidnapping. Caitlyn had kidnapped Dustin's child before. She had a plan to kidnap his children again. She told Dustin he would never see his children again, and she was holding Elowen hostage in front of him. Dustin reasonably believed that Caitlyn was committing or about to commit a kidnapping.
This was not an accident. This was not defense of others. This wasn't done to prevent a kidnapping. It was murder. And he knows it. He knows. And that's why he's changed his story over time. He's taken time to craft what he's wanted to say. It's why he's changed what he told the police after he was caught to what he testified to on the stand. It's why he's tried to blame Caitlyn Naffziger for her death. The real victim here, the victim that you're here to decide this case about, is the unarmed woman who the defendant shot in the head.
Yeah, that's what the prosecutor was saying. Defense counsel during the closing talked about the fact that the defendant, their client, is a Marine, suffers from PTSD. How that will play with the jury, we'll have to wait and see. Ted and Julia?
Kind of leaned into it when he took the stand, his training, to sort of say, well, we're trained to be killing machines, and it had that feeling where it was half self-defense and half I'm a robotic Marine that doesn't think for himself.
He did, Ted, and one of the words he used was meticulous. So that's how he described the shooting of Caitlyn. He used that word meticulous, and that's another thing we heard defense counsel say in the closing, talking about the fact that he's trained to see a threat and then act upon a threat, and that's exactly what he did in this case. So he took the stand. He told us all about what took place in this situation according to what he says. Now, the prosecutor has said that he has changed his story several times, but let's go ahead and listen to a little bit of what he had to say when he was testifying.
Really trying to ask, like, what is going on now? Like, something is seriously wrong. What is going on? And this is where she first starts really talking, and where now she's making these demands for just a substantial amount of money that there's no way that I could pay her. And I'm telling her this, like, I can't get you this kind of money. Like, I don't have this kind of money. I'm paying you what I can. I'm sending you what I can. I can't pay this. And then at this point, this is where she's saying, or now threatening that then, oh, if I can't pay her, then she's going to say that I kidnapped Elowen from Minnesota without her permission, and that she was going to call the cops and have me arrested, and that then I would never see the kids again.
Yeah, he was saying on the stand that she was demanding about $2,000 a month, and that if he didn't go along with this plan, she was going to call the police. So all that is sitting there with the jurors now as they continue their deliberations. About 19 minutes now, and we will keep you posted, Julie and Ted, as soon as there are any developments in this case.
Kelly Craft, legal correspondent, thank you for the update. I know you're going to tell us if there's a verdict. I like your prediction that it shouldn't take too long in this case. Still with us, criminal defense attorney Marie Pereira standing by. Got to get your thoughts on this one, Marie. He took the stand. He went as far as you can go as a defendant to get the jury to see it from his point of view. Do you think this is going to be a challenge for these jurors?
Not at all. I'm looking at the clock. It says 19 minutes, 59 seconds. They should have been out already. And I'm trying really hard to come up with big legal analyst words, right? To bring it home. But he just created the motive. He said, she asked me for money, more child support or whatever. I didn't have it, and she was going to tell a lie on me. So it really says that he really had time to think about it and says to himself, the only way to do this is to shoot her. They testified that she was on the sofa with a blanket next to her and her phone. It wasn't like she was running, she was driving away and he was shooting at the car to stop her from kidnapping her own children. He did it on purpose. And then in other interviews, he said, I was fully aware, alert, oriented, able to make a decision, and that's basically the decision I made. I had to shoot her. The jury should have been back already. They should have been back. My God.
Well, there are 4 counts, and you have to pick a 4 person.
You do, and they may not even have all the evidence back there. Sometimes it takes them a minute.
Lunch, and, yeah.
We're trying to help them out, Marie. 21 minutes and counting, and I like what Marie said. Clear head. That's something he said during his interrogation. I had a clear head. I don't know who would ever admit in any situation to having a clear head.
Yeah, the problem with his defense, to Marie's point, is that he's basically admitting it. He might as well just get up and say, yeah, I shot her in the head because she was driving me crazy.
Mm-hmm. And I was mad at her.
I shot her and I hated her.
I was so mad at her.
Yeah, exactly. It's like, all right, well, that's what every murderer does. That's how murders take place.
Mm-hmm.
And it's against the law for good reason. Yeah, it's
Let's not forget about the part she was asking him for money. He said, she was asking me for a sum of money I didn't have. So clearly, he did that to her in revenge against what she was saying. I'm going to tell a lie on you. He put himself out there. 21 minutes, jurors, 22, they need to come back already. They needed to come back already.
Well, we'll keep our eye on it, and as soon as they come back with a verdict or a question, I can't imagine there'd be too many questions, but you never know.
Never know with a jury in New Hampshire.
Hey, if you get a 4-person that wants to relitigate the case or something, you
go through the instructions.
Yeah. It can take a while, so we'll see what happens here. We'll get a break. When we come back, we'll go back to Virginia. More of that civil case. First grader shoots a teacher. We're watching that play out. Stay with us.
An Amber Alert triggered by a deadly shooting and 2 girls taken by their father.
But did Dustin Duren shoot the mother of his children in self-defense?
The Amber Alert murder trial. Live coverage today on Court TV. This week on Opening Statements.
These are the biggest true crime cases across the country, and we have you covered each weekday morning before the proceedings begin.
Opening Statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
Welcome back to Court TV Live. We are back now in Virginia. It's day one of a civil trial that's connected to a lawsuit that was filed by a former elementary school teacher, Abby Zwerner, who is initially suing the school district, but she's also seeking $1 million in damages after she was shot by one of her students who was just 6 years old.
Yeah, and now basically we're watching this civil trial play out from Virginia, and the defendant in this case is an assistant principal who, according to the plaintiff, should have acted differently to prevent the shooting. After there were reports that the 6-year-old had brought a gun to school, the allegation here is she didn't do what she was supposed to do and investigate and stop this threat.
All right, and she's being sued individually, so she doesn't have the school board, the school system behind her. She is the only one at this defense table. We're picking it up where we left off. The witness on the stand is someone who worked in that school, a music teacher.
Not specifically.
Okay. If you would flip to, there's a little red number at the bottom that says 9074. If you go to that page. Does that refresh your recollection as to a portion of this staff handbook that addresses classroom management and safety?
Yes.
And do you recall, without looking at it, I know it's right in front of you, but do you recall without looking at it whether there are tiered behaviors within the handbook?
Yes. Your Honor, I object to this stage in this line of questioning. I don't see how this is assisting the finder of fact. I would ask for a proffer from opposing counsel. What is the relevance of this?
Yeah, how does this go towards anything that was brought up in cross-examination?
Your Honor, he asked about responsibilities. The tiers within the handbook delineate responsibilities of administrators and staff members in situations of classroom safety. It's been the position of the defendants, both in cross so far and in opening statement, that there was responsibilities shared amongst individuals, and there's a handbook applicable to their relationships that tell us what their responsibilities were. If he didn't ask he asked the question about duties and responsibilities, and so we get to explore what duties and responsibilities were being attended to by Dr. Parker.
I'm going to overrule it. The door's been opened in cross-examination. Objection noted.
Good. And based upon this staff handbook, there's level 3 behaviors, true?
Yes.
And what does it say about level 3 behaviors, as best as you recall? And if you need to refresh your recollection by looking at it, that's okay.
Level 3 behaviors are reported to school security and administration.
And is there a description is there a section that talks about student behaviors specific that are level 3 behaviors?
Yes.
And is there a student behavior within the handbook that specifically applies to a circumstance we're talking about here today?
Yes.
And what does it say?
Your Honor, I object at this stage. This is lack of foundation for the basis of this witness's knowledge. It sounds like he doesn't have any independent recollection of this document. He's just being asked to read from this document itself. To the extent that there was an argument about opening the door, I still stand on my prior objection that this is a discrete issue. I mean, this is his bare recital by a fact witness of what is written in the internal policy has no bearing on our proceedings here. This has no bearing in this case. I would object on the grounds of relevance as well as 2-4-3 balancing, because this is going to invite the jury to render its verdict based on an improper basis that has no relevance. It's a collateral matter.
All right, in response to relevance objection now.
Your Honor, I believe the foundation was just laid with the witness that first, this is a staff handbook that applied in January of 2023. He was able to identify it as a staff handbook that applied in January 2023. And when asked whether there's a level 3 tiered behavior that specifically is pertinent to the issue here, he says yes, it's within the handbook itself. We've laid the appropriate foundation. It's certainly relevant to the issues in the case, especially in the circumstance in which the argument's been posed to the jury that this is a case about indifference and not inadequacy. And so what the individual knew, the defendant knew about their responsibilities and how to balance and weigh those responsibilities is certainly pertinent. And in light of the fact that they've crossed this individual on the fact that she was tending to her responsibilities on that day. It's relevant for us to address what other responsibilities she agreed and promised to keep.
Right. Overruled on foundation, relevance. I think those were the two latest ones. Go ahead.
Under student behaviors, is there a specific behavior that we've been discussing so far in your testimony?
Yes.
And what does that say?
Possession of a weapon.
And does this, as best as you can recall, or if you need to refresh your recollection, talk about what next steps and responsibilities to take next steps are on the administrator, the assistant principal?
To secure students and ensure safety.
Is there others?
Immediate notice to administrator and security. Email a detailed account of the incident and everyone's roles, names, locations, and time.
Now, you were asked about whether Dr. Parker focused on her duties and responsibilities. Based upon your observation of Dr. Parker during your first conversation, between your first and second conversation when she was in eyeshot and your second conversation and after, did you observe her attend or focus on any of those responsibilities?
Your Honor, I object. He's calling for expert testimony. He's not an expert.
I've overruled that right now. You want to object that it requires expert testimony? I'm overruling that. Go ahead.
Do you recall the question? You want me to ask it again?
Can you ask it again?
Yes, sir. From the time that you had your initial conversation with Dr. Parker, and then you sat at the registrar's desk, you could see Dr. Parker. Then you had a second conversation with Dr. Parker. During any of that time, did you observe her take any actions that were focused on the responsibilities that we've just addressed in this handbook regarding the possession of a weapon?
Because of the position of the registrar's desk, I'm actually facing away from her door, so I couldn't tell you what she was or was not doing.
During your time there, did you see the student JT come into the administration office?
Not that I recall, no.
Did you see Dr. Parker leave her office to go potentially look for him?
Not that I observed, no.
Did you overhear her notifying security?
No.
Now, there was a question asked of you in cross-examination about not knowing where the gun was. You recall that question?
Yes.
Okay. Did you observe Dr. Parker take any actions to try and locate where the gun was?
Not that I recall.
All right, we have to slip in a break, but when we come back, the guidance counselor is going to take the stand. What did they see and know? Welcome back to Court TV Live. I'm Julia Janae, along with Ted Rollins. Thank you for following along with us as we begin this hour in a case that's a pretty rare one. A teacher is suing a former assistant principal for millions of dollars after she was shot by a student.
Abigail Zwerner suing Ebony Parker, the former assistant principal at Rich Neck Elementary School, for millions. And it's because the plaintiff claims the defendant ignored multiple warning signs that a 6-year-old had brought a gun with him to school.
Now, Zwerner was shot back in January of 2023, and those injuries resulted in a collapsed lung. So let's get you back into court now. We're listening to testimony from people who were at the school, people who can say whether or not this principal should have known about the 6-year-old and the gun. The guidance counselor is on the stand now.
Please report. Good afternoon.
Good afternoon.
Good morning still. I apologize. Could you go ahead and state your full name for the court reporter?
Alonzo Duran Rawls, Sr.
And Mr. Rawls, what do you do for work?
School counselor.
And what school system do you currently work with?
I currently work with Virginia Beach Public Schools.
And before your time with Virginia Beach Public Schools, were you employed by the Newport News Public Schools?
I was.
And what was your job title then?
School counselor.
And what school, if any, were you working at in January of 2023?
Rich Neck Elementary.
And were you at work on campus January 6, 2023 at Rich Neck Elementary?
Yes.
Mr. Rawls, I'm going to show you if we can publish, read. It's a little roadmap. It should pop up on your screen.
Okay.
And it's just to give you an idea of the nature of the questions that I'm going to ask you today, okay?
Okay.
So we're going to talk about information generally, but I want to talk to you first about what you learned on January 6th, what you shared and who you shared it with,
okay,
and then what information you received back, okay?
Okay.
On January 6th, was there a time in which you had a conversation about a student who we're calling JT?
Yeah, or later that afternoon, I had a conversation about JT.
And when you say later, give us a context of what that means in your life at Rich Neck.
Probably late afternoon. Rich Neck was what's called a B or C school. I can't remember exactly how they determined it, but it was a later school, so normal time they didn't dismiss until around about late 3:45, almost 4 o'clock. So I believe on that date, it was around, probably it was after 12, so I'd say between the hours of 12:45 to like 1:15. Around that time is when I was informed about some information about JT.
And who informed you of information about JT?
Well, originally, it was kind of like indirect. I spoke to Miss West, who was the teacher, first grade teacher across the hall from Mrs. Soner. So she had brought to my attention that there was a student from her classroom that was transferred over to her classroom that was very upset about a situation that he was information was passed on to him that really was upsetting him, and she wanted me to speak to him, that particular student.
I'm going to unpack that a little bit just to make sure we're tracking. And my understanding is that you used to call Miss Werner Mrs. E, is that right?
Yes.
And it's totally okay to call her Miss C in the courtroom as well. So you had a conversation with Miss West in which she communicated that there was a boy that was in her classroom that...
He was currently in Miss West's classroom, but he was in Miss Z's classroom as a student. Yeah.
Got it. So, again, I just want to make sure everyone's tracking.
All right.
This is a boy that's not JT, correct? Who was assigned to Mrs. E's classroom on a normal day-to-day basis.
Correct.
And on this day, January 6th, he was physically in Miss West's classroom.
Correct.
And that classroom is across the hall from Miss Z's classroom.
Correct.
And it was while he was in Miss West's classroom that Miss West shared with you that she gathered information from this boy.
Yes.
And just the first initial of the boy, just so we can track him. What's the first initial of his first name?
R.
And so this boy, R, did Miss West share with you what the boy R shared with her?
Yes.
And what was that?
Basically, she said he was upset because JT, during recess time, had mentioned to him something to the fact that he had some type of ammunition or bullets, I think the terminology was utilized, and he showed him or displayed it to him, and during that time, he also told R that if he had told anybody that he was going to harm him in some type of way. I think the word was to shoot.
And again, I just want to unpack so we're tracking the people correctly. It was conveyed to you that JT had informed R that he had bullets, and that if R said anything about it, JT would shoot him.
Yes.
Did you interpret that as a threat?
At the time when I spoke to R, I did not, because he was not very coherent about what he was trying to display. And personally, I just didn't think, because I've spent a lot of time with JT. I had been part of his, treatment plan for like a year and a half. So.
And we're not going to get too.
Yeah, but think along so short. No, I did not answer the question.
Okay, but you did. It raised concerns enough to you to have a conversation with Dr. Parker.
Yes.
And those concerns were specific about the report that you had just received about something with bullets and shooting.
Yeah, because normal time we have that, you try to investigate, so we wanted to look into it, yes.
And so from that information, did you then, so that's sort of what we learned, right? So we have bullets plus a shoot. And did you take that information and share it with anybody?
Well, I can't recall if I shared it per se, besides the teachers who already shared it with me, but we did want to look into if he had some type of ammunition or things to figure out where that might be at. So we asked about the backpack and where he might store that particular items at.
And you're using the term we,
yeah.
So I just want to make sure we're tracking who the we stands for there.
Well, we at the time would probably be Miss West and Miss Z.
Okay, and so this is a conversation amongst you three. And then did you then take that conversation and go talk to Dr. Parker?
Yeah, I asked because they said that they had already, I was informed they had already checked his backpack. The backpack was in possession of the administration at that time. So I said, well, even if they checked his backpack and nothing was in there, had they checked his person? And they said nobody had checked his person at that time. So my request was to go to speak to administration about checking his person.
And was that your understanding of how things went at Rich Neck Elementary?
To an extent, in my experiences.
Okay. And so you go to administration. Who do you go to specifically in administration?
Principal or assistant principal, whoever is in part of, like my boss or in charge.
And on that day, January 6th, who did you go speak with?
I spoke to Dr. Parker.
And when you went to speak with Dr. Parker, did you ask about searching the person?
Well, we discussed about the backpack, and then I did ask, would it be okay if I checked this person? Yes.
And what did Dr. Parker say back to you?
She basically said, because he was on a certain plan, that they had already checked the backpack, nothing was in there. So she said, well, his mother will be coming to get him soon, so we can hold off and wait, and maybe when the mom comes and pick him up, we can check his person at that time.
And did you interpret that conversation as giving you permission to go search JT?
No, I took it as in she wanted me to hold off, and I didn't want to step over any boundaries, so I wasn't going to check him without permission, so, because we didn't have any security or anything at that time.
And so, do you recall approximately what time that conversation ended between you and Dr. Parker?
I don't recall the time.
Do you recall at some point in time, just so I'm tracking in terms of timeline, we just talked about information received,
right,
which was your conversation with Dr. Parker.
Right.
And other than what we've just addressed in terms of information received, the statement she made to you about waiting for mom, was there any other information that she conveyed to you at that time?
Not that I recall, no.
What did you, Mr. Rawls, do as a result of that conversation?
I just went back. I left out of the office, and I did go back to Mrs. Z's classroom, and I walked into the classroom, and I do remember Mrs. Z was in the back of her classroom at like what they call the moon table, and as the students were working, and I expressed to her, I said, well, I spoke to Dr. Parker. She said she didn't want me to check his person at this time, and I told her if she needed any more assistance, just to let me know. And that was pretty much it. After that, I left and went back to my office.
How soon after that conversation with Miss Z did you receive any sort of information about a shooting?
I didn't receive anything until they came over the announcements with the lockdown.
And tell us about what you heard then.
Well, when the lockdown originally went, it just sounded like it might have been a drill. And in any school lockdown, you know, you're supposed to stay in place, lock your doors and things of that nature. So I just proceeded to do so, cut my lights off, turn my door down, because my office is far on the other end of the building where the classroom is at. But then maybe momentarily, maybe a few seconds after that, another frantic lockdown was mentioned over the loudspeaker, and I knew something was not right.
And when you say you knew something was not right, what did you do after you heard the frantic call? I know, Mr. Rawls. It's okay.
I got on the walkie-talkie and asked did anybody need assistance, and no one answered. So procedure is not to leave my area, but I left my area to go around the corner to see what was going on. As I proceeded to go around, passing the cafeteria area, down the main hall, and there's another main hall area where it heads down to the front office. There were janitors in the hallway, and I could see speckles of blood on the floor. And we were cleaning it up, and I said, you know, what are you guys doing? You know, it's a lockdown. You know, I ain't supposed to be out there. And one of the janitors mentioned to me, they said, they got him. And I'm like, they got who? And they were like, the student in the classroom down here. So I proceeded past the janitors into Mrs. Z's classroom because the only door was open. And as I stepped in, Mrs. Womack, Miss Amy had JT over in the corner, and she had him like in a hold, not like a restraint, but like just hold, like holding him by his arms. And I said, what's going on? And she said, he shot her. And I said, he did what? And she said, yeah. And I said, where's the weapon? Where's the gun? And she had pointed across to the hall. So I walked through the classroom on the far end, and the weapon was on the floor. My initial reaction was because another janitor was still inside the classroom at the time as well, and I didn't know would he try to break away from the reading specialist, Miss Amy.
Hitting the pause button on this testimony. Let's bring in our guest for this hour. Los Angeles, California is where she is. Criminal defense attorney Marie Pereira. Oh, Marie, things just turned inside of that courtroom with the testimony from the guidance counselor. It just reminds you just how horrific that moment had to have been. Not just for, you have a teacher who was shot and thankfully she survived, but in that moment, you likely don't know what's happening. There's a gun, there's other 6-year-olds, there's other first graders in this school that you have to protect.
My heart was racing when I heard the testimony. This is a very impactful witness against the principal because he was actually there and they had a discussion. He said, I think there might be, something in his backpack. And she instructed him as someone who had a superior position over him to wait until the mom came. And that decision almost cost the plaintiff her life. Because had they checked his backpack, maybe he wouldn't have done what he did because they would have found the gun. This is a terrible, terrible witness. against her, and I think he's very believable. He's almost choked up about what happened, and it goes to foreseeability, more importantly. It goes to the duty she had to protect that teacher. It goes to the breach of the duty, and it goes to causation. The injury we don't have to worry about because it's right there, her lung collapsed from the gunshot, but the foreseeability in her seeming indifference to the safety of everyone in the school. Just check the backpack. Just give him permission to do it. And it is just horrible in terms of the inadequacy of her leadership and the causation of what happened to that poor woman getting shot like that. It could have been prevented. It was foreseeable because they thought he had a gun in the backpack. He's 6 years old. Just take the backpack and say, I have to check it.
Yeah, or even just take the backpack until the mom gets there. If you're concerned about the mom not being there during this, take the potential. Obviously, she didn't think there's a gun in there, right? Hey, we think there might be a gun in there. She probably is assuming or saying to herself, all right, I doubt it. Let's get the mom in here. Let's do it the right way, even though she's doing it the complete wrong way in hindsight. And this is a lot of hindsight, which I know is 2020. And to that point, Marie, will a civil jury take pity on this assistant principal over the course of a trial of this length? Because let's face it, this is a person that I'm sure is inundated on a minute-by-minute basis with this crisis, this, and the other. Albeit it's not a gun in a backpack, but it's a tough job.
It's a tough job, and will they take pity on her? Perhaps, because when I first saw her sitting there, I'm like, oh my God, they're blaming this poor woman and suing her personally for $40 million. Where is she getting that kind of money? She's probably bankrupt. She had to hire counsel. Her life is ruined. But then, as they're piling on the witnesses to say, I told her I thought there was a gun in the backpack, and then she told us, don't look in it. It's making me see that she's incompetent in her leadership. And I'm not so sorry for her anymore because there was a way to prevent it. All she had to do was listen to the people on site who were concerned, and out of an abundance of precaution, like you said, Ted, just take the backpack. What kind of privacy rights does a 6-year-old need? What did she think she was going to find in their crayons? There was a gun in there. She could have kept it, like you said, until his mother came.
And the financial part of that, I love that you're saying it, no doubt how the jury sees it. For our viewers to know, there is an insurance policy that is going to help her. It's helping her with her counsel. It helps her with liability coverage, so they may be the ones paying for this if she is found liable for an amount. But the jury doesn't know about that insurance coverage, so they could be seeing it just how you are, knowing that she's definitely lost her job at this point, and she may be in some ways insolvent and bankrupt.
Yeah, and the insurance company would likely also be making the call whether or not to settle or go to trial, and that is partly why she's sitting there as a defendant in a civil case. Let's get a break. When we come back, more testimony out of the state of Virginia. We don't normally cover civil cases. Usually it's all criminal. Oh, and speaking of criminal, TikTok, they're almost up to an hour in Duren. We'll watch that as the Verdict Watch continues in New Hampshire. Stay with us.
An Amber Alert triggered by a deadly shooting and 2 girls taken by their father.
But did Dustin Duren shoot the mother of his children in self-defense?
The Amber Alert murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, missing baby Emmanuel's father pleaded guilty to murder. But what's next for the mother? We're unpacking today's big hearing in the case against Rebecca Harrow.
Closing Arguments with Vinnie Politan. Tonight at 8, 7 Central. Only on Court TV.
We'll head back to Virginia in just a minute, but first, here's a quick look at some of the other cases we're tracking here at Court TV. In New Hampshire, a jury has been deliberating now for over an hour and 2 minutes in the Amber Alert murder trial for Dustin Duren.
And in Florida, the state is expected to rest their case in chief today in the murder of Julio Folio trial, but not before the jury sees the defendant, Alicia Andrews' police interview.
In Wisconsin, testimony continues for a man accused of killing his longtime girlfriend, then dumping her body on the side of a road.
And in California, mother Rebecca Haro could be pleading guilty this hour. We will see. There's a settlement conference for the death of her 7-month-old son, whose body has not been located yet.
And we thought that was a hearing. That was originally scheduled for 11:30 Eastern. Now it's 1:30, so they'll be there, and it'll be interesting to see. We'll keep you updated on all of these trials as the day progresses. But right now, back to Virginia for the first grader shoots teacher civil trial.
Yeah, still on the stand is a guidance counselor who's been giving some really emotional testimony. He worked with the 6-year-old shooter and other students. He's talking about the day it happened. Let's go back in.
Quick follow-up?
Yes.
Was the police on scene yet?
No.
Okay. And so you saw the weapon on the floor in the classroom before the police arrived?
Yes.
And then from what you could tell in your observation, did the gun stay in that location until the police arrived?
Yes, because like I was saying, I was going to move it because I wasn't sure, but he's going to try to get at it again. But I wasn't going to touch it without a glove or something, so I asked the janitor or so to get me a glove or something. And before that even occurred, that's when the officers did proceed into the classroom.
Thank you, Mr. Ross.
Mm-hmm.
Prior to January 6th, was there ever an occasion in which you attempted to search a student for another reason?
Not that I recall, no.
Were you ever provided, or were you ever given any warnings or reprimand not to search a student without someone present or administrators present?
Not that I recall, no.
Understood. Thank you.
All right, any cross-examination?
Yes, Your Honor. Good morning, good afternoon, Mr. Rawls. How are you? I just have a few questions for you so the jury can hear the whole story. You mentioned that you'd worked with a student before, JT,
Yes.
and you were part of his student success team, is that correct?
Yes.
Okay, and he had some behavioral issues?
Yes.
And he also had some learning issues?
Yes.
And you were very familiar with him?
Correct.
And he had been taken to Dr. Parker's office on multiple occasions?
Yes.
And in fact, 2 days before, he threw Ms. Werner's cell phone, correct?
Yes.
And you were called to her room either by Ms. Werner or Ms. West, correct?
Yeah, I was called on the walkie-talkie.
They told you, come down and get him and take him out of here, correct?
Yes. Yes.
Okay. Now, Friday, January 6th was a little bit different, wasn't it?
Yes.
You were, in fact, dealing with student A, with Ms. West's class?
Okay, yes.
And you and Ms. A were dealing with student A who had caused a major disruption in the school, correct?
When you say a student A, who are you referring to exactly?
The student A who was in Ms. West's class that you had taken to your office. Do you recall taking a student into your office to counsel them? Student A.
That wasn't Mrs. West's class. That was another student, and she was a first grade student, but that wasn't Mrs. West's class.
Okay, so you had brought student A back down to the classroom.
Yes.
Right, and then you learned Ms. West talked to you about something she wanted to tell you about student R.
Correct.
Okay, but Ms. West didn't seek you out.
No, that I didn't think of, no.
You came down the hall and sort of stumbled on this information.
I stumbled onto the information.
So at that point, you had heard nothing about JT that day?
Not to that point, I recall, no.
Okay. In fact, you knew he'd come back from suspension?
I knew that, yes.
Okay, and at some point, you'd checked in to see how he was doing that day?
Yeah, I think I walked past the hall. I don't think if I came exactly into the classroom, but I came down the hallway area.
Okay, and you hadn't heard anything other than what student R told you?
I recall, no.
Okay, so you took student R outside in the hall and spoke to him?
Yes.
Never heard anything about a gun?
No, not about
You
her.
heard something about bullets? And because student R was 5 or 6, you decided, did you feel like you needed to investigate it?
Well, yeah, that's why I went to ask about the bag and everything, yes.
Okay. And Ms. Werner never sought you out about JT that day, correct?
Not that I recall, no.
And you didn't hear any walkie-talkie traffic about JT that day?
If it wasn't direct towards me, no.
Okay. And so you spoke with R outside of Ms. West's classroom.
Mm-hmm.
And when you spoke with R, you didn't feel the need to take him to the office, correct?
Oh, R?
Yes.
No.
And JT was across the hall in Ms. Werner's classroom?
Yes, I believe so.
And you didn't feel the need to take R out of the classroom, did you?
Not at R or at JT?
JT.
No, not at that time, no.
And you are a member of you're a guidance counselor and you're involved in discipline and counseling students on discipline?
Well, yes, guiding them, yes, not so much in charge of discipline, no.
But you do counsel students?
Yes.
And you're probably a member of the threat assessment team at the time?
Yes, probably.
Okay. So at that time, you did not feel the need to remove JT from Ms. Werner's classroom?
No.
You didn't feel the need to clear the classroom?
No.
Didn't feel the need to call for a lockdown at the school?
No.
So what you did is you went and talked to Dr. Parker?
Yes.
And you and Dr. Parker had been talking about student A as well, correct?
The one that I brought back from the classroom?
Yes.
I may have mentioned, but that was a situation that I knew was kind of under control after I brought that student back. Yes.
Okay. So if Dr. Parker was involved in dealing with student A, you just don't have any knowledge of that?
No, I don't know.
Okay. So you go back and you talk to Dr. Parker and you tell her, you have some conversation.
Yes.
And that was over many years ago now. We're past 3 years ago?
Yes.
And do you recall the exact details of the conversation?
I don't the exact details. I just know that it had been brought to my attention about the backpack had been checked, and what had been said about the ammunition or bullets, and I was like, well, if he has nothing within his possession within the backpack, would it be okay to check his person? That was the conversation I do remember.
Okay, and Dr. Parker didn't refuse refuse a search of the person, did she?
I don't even want to call it refusal. She just said we would hold it off. It was not that the fact that maybe she didn't want to check later, but I know it was at that time. No, she didn't want me to check.
She didn't want to check at the time. She wanted to wait for his mother to get there. And you've stated that you understood why, because he's 6 and checking a person.
Yeah, I just didn't want to step over any boundaries in that situation, no.
And you didn't feel the need to go around Dr. Parker, did you?
No, I did not.
You didn't feel the need to track down Principal Newton and say, Ms. Newton, we've got a situation here. Dr. Parker won't let me search that child.
No.
You didn't feel that at all?
No.
And in fact, you decided to go back to your office.
Yeah, I went back to speak to Mrs. Zorner first, then I went back to my office, yes.
Okay. And then you were in your office, and at some point, you understood that there was a lockdown.
Yes.
And you came down the hall.
Yes.
And you saw the janitors.
Yes.
And they were mopping blood.
Yes.
And you understood did one of...
All right, let's get a break. In hour 10 in Duren, we'll go back to Virginia. More of the civil case with the guidance counselor on the stand. Busy day at Court TV. Stay with us. Welcome back to Court TV Live along with Julia Janae. I'm Ted Rollins. We're going to head back to Virginia now for more of day one of the first grader shoots teacher civil trial.
Yeah, this jury, they heard the opening statements and now they are hearing from witnesses. This is all part of what was originally a multi-million-dollar lawsuit by teacher Abby Zwerner. She claims that while she was a teacher at an elementary school that one of the students, a 6-year-old with a history of issues, shot her.
She says that a former assistant principal, Ebony Parker, and that's her at this, on your screen, ignored teachers concerned about this student and a story that he may have a gun in his backpack.
Let's go back into the courtroom now. More testimony from the school guidance counselor who said that he did make a suggestion to this principal to look in the child's backpack.
Did you say, oh, it's JT, it must be JT? Is
No.
that what
No,
Did you
that
have
was
any
my-
idea who they were talking about?
I had no idea.
And it wasn't until you went in the room
Yes.
that you knew that it was JT?
Yes.
And the law enforcement came,
Eventually, yes.
and after that you went back to your office
Yes.
and you cried, didn't
Yes.
you? Because this was shocking to you.
Yep.
And Mr. Rawls, at any time when you were dealing with this situation, up until the time you saw that child in Miss Kovac's room, did you ever think that JT was a threat to that school?
In my personal opinion, in the time I spent with him, I wouldn't have thought he would have took it to that level now.
Did you think that you were comfortable leaving him in the classroom while you had the conversation with Dr. Parker and then going back to your office? It was an evolving, and isn't it true that it wasn't a credible threat at that point?
I didn't think it would have been, no.
That's all the questions I have.
Any regret?
Yes, Your Honor. Mr. Rawls, you were asked about your feelings and how you didn't feel like you needed to ask or do certain things that day. Do you recall that?
Right.
You did have a bad feeling, though.
I felt more regret after.
Well, when you were interviewed by Ms. Farish, do you recall that? She was with the Newport News Public School System.
Oh, yeah. I mean, I know he had a lot of concerns, and he had anger management issues, and maybe so because the interaction me and him had was different than he might have had with other people, and maybe that's why I didn't feel he was such a credible threat. But I can't determine if that's how,
Right, and sometimes people's actions towards different people varies.
All right.
And this is a 6-year-old who 2 days prior took specific action against Mrs. Z.
All right.
And so you had a good understanding at that time that she might treat her differently that he treated you.
Yeah, yeah.
And when you spoke with Ms. Farish and you were talking about the incidents, that was close in time to when it actually happened, right?
Right.
It was in January of 2023 that you had that conversation.
All right.
And when you went into Mrs. Z's classroom with the information from Dr. Parker, that was sort of hang tight.
Yeah.
What was Mrs. Z's demeanor?
I just remember her facial expression. It was kind of like a look of shock. And her eyes were very wide, and she just kind of looked at me very strangely. That was the outcome of my request. But that's why I try to encourage her that I would be there for her if she needed me.
To hang tight. And is that one of the reasons you didn't have a good feeling?
Probably.
You were asked earlier about never having heard anything about a gun. Do you recall that question? I'll give you a moment. someone said the word gun to you, would it have changed your impression?
If I put myself back in that moment, and like I said, a lot of time has elapsed, I can't definitely say what my thoughts would have been.
Okay. And when it was conveyed to you that it was bullets, and you had asked for permission to search this person, what was it that you, in your mind, were searching for?
In my mind, I would probably search and see if he might have had some type of item of, you know, because sometimes we talk about elementary students that have been doing this job for a long period of time, and you know, bullets could be like, somebody might think a bullet was like the end of a pencil eraser. I explained this before, or some different item that might have been the shiny. So it's just the fact that the reason why I asked to search this person, because I want to be more definite about if he has something on this person or not.
And that includes search to see if he had a gun.
Right.
And the message that you learned of was that it was bullets, and if he says anything about it, he's going to shoot.
Right.
How do you shoot bullets?
Sometimes you shoot with a gun.
Those are all the questions I have.
Any cross?
Just a few. You were, Mr. Rawls, you were asked about the interview by Ms. Farish, is that
Right.
correct? Do you recall in the interview with Ms. Farish talking about feeling guilty for not preventing the shooting?
Right.
And did you recall saying that that's hindsight
Objection,
bias?
Your Honor. Relevance.
All right. What's the relevant?
He asked about the interview with Ms. Farish.
Yeah, you kind of opened the door on his feelings, so I'm going to overrule that.
That's okay.
And do you recall saying that's hindsight bias that you were feeling?
Hindsight bias. Regret, guilt. Hindsight bias. I don't know how to have hindsight per se. If you look at it in my vision, it's just maybe if I could have done more. So if you say hindsight in that position, then yes.
And do you recall Ms. Farish saying to you, none of us could have ever imagined
Objection, Your Honor.
that something like this would
Objection,
occur?
Your Honor.
Yeah.
She keeps going.
Yeah. An objection has been made. Do you have any response that you would like to make to that objection?
He brought up the conversation with Ms. Farish.
All right, but what's your specific objection then?
Objection. The objection is the statement of Ms. Farish is a hearsay statement.
The question itself is hearsay. Do you have a response to
It's
that?
not offered for the truth of the matter asserted.
What's your response to that?
Your Honor, there is no other purpose that it could be offered other than the impressions of somebody who is not relevant to the matter here, and it's hearsay, whether or not it's relevant.
All right, I'm going to sustain the objection, and I'm going to order that it be stricken from the record and you not to consider any of that language that came from the question, came from an attorney, and is not testimony. All right, thank you. All right, any other questions?
No further questions.
Okay, thank you. All right, do you want him excused or either resequestered or on leave?
He's released from our subpoena, Your Honor.
Okay.
He's under subpoena with the defense, so
Okay.
we would ask that he remain in contact with us if we need to call him again.
All right, and you have the ability to contact
All right, the guidance counselor may be on the stand again once the defense case starts. Coming up, we're going to have another witness on the stand for the plaintiff. A fellow first grade teacher is going to be taking the stand to talk about what happened that day and what they knew. We'll be right back.
I ended up asking him if he loved me. He said, I don't know. I said, do you love her? He said, I don't know.
That set you off?
Someone was stabbed? Yes, she's on the floor. I didn't have the intent to kill Sarah. I really just wanted to scare them.
It looks more like fury than fear. Did you kill Sarah to possess what she had with Josh? Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
Let's go back to Virginia for this civil case between a former principal and a former elementary school teacher, Abby Zwerner. She's suing. Initially, the amount she was asking for was $40 million, stemming from an incident back in 2023 when a 6-year-old student shot Zwerner inside of her classroom.
Yeah, she had a collapsed lung, shot through the hand. Her attorney says that their client, other teachers, and even students warned school administrators, specifically former assistant principal Ebony Parker, that a 6-year-old had brought a gun to school and that those warnings were ignored. That's their claim.
Let's pick it up where we left off. The next witness on the stand for the plaintiff in this case is another teacher at Rich Neck Elementary School.
Appreciate that. And may you state your name for the record, please, and spell it for the court reporter?
Jennifer West, JENNIFER-WEST.
Thank you. And Miss West, can you tell the jury, how are you currently employed?
I'm a first grade teacher at Rich Neck Elementary.
And how long have you been a teacher?
23 years.
Where were you on January 6, 2023 as a teacher?
Rich Neck Elementary.
And which grade were you teaching then?
First grade.
And you're familiar with Abby Zwerner?
Yes.
Okay. Can you tell the jury how you knew her on January 6, 2023?
She was my teammate and taught across the hall.
And tell the jury on that day, did something happen at recess that stuck out to you?
Yes. My class was a few minutes late going out to recess. Abby's class and another class were already outside. When I got out there, I was told that, or Abby told me that she saw JT take something from his backpack and put it in his coat. And I spent the rest of recess kind of watching JT and another student, R. They kept going behind the tree at the playground, and then R would walk away. They'd come back together, and I witnessed that for 15 or 20 minutes while we were outside.
And then after recess, tell the jury, where did you go immediately after recess?
I went initially, and we had a second entrance into the school. I had a student that was acting aggressively, and I opened the side door and he took off into the hallway, and I followed him down that other hallway towards the office. And when I got to the office, I hollered inside to Mr. Sims, our music teacher, who was standing at the counter, and told him I needed some help with this student. Continued down the hall, and when I got to the corner, the student turned right, and to the left is the first grade hallway. And at the intersection, I ran into Mr. Rawls and Dr. Parker.
And let me slow you down right there. What did you do with the rest of your class when you went after the other boy?
We were in the process of lining up from recess, and when we come in from recess, one teacher typically would blow a whistle, and every class would get in line with their teacher. And so my class walked inside with Abby's class and the other. I don't remember if the other teacher had gone in yet or not.
And just so the jury understands, so when you're at recess, it's typically all the first grade students?
Yes.
Okay. And so back to, you said you saw Dr. Parker and you saw John Sims.
Yes.
And then where do you go from there? Do you turn back to your class?
I went to my class, yes.
So as you're walking to your class, is there anything you do involving the other student, R, who you saw with JT at recess?
I did. I asked to speak with him, to ask him what was going on at recess.
Let me just ask you, why did you talk to R?
Partially to find out, because we were watching their interaction.
To find out what?
What they were, it seemed that something was being hidden at recess. And when I pulled R out of, I can't honestly remember if it was from the line or from the classroom, but I pulled him to the hallway.
And let me ask you, was there anyone else in the hallway with you as you're talking to R?
Not initially.
Okay.
Abby may have been standing at her door because we had both our classes. And I asked him what was going on. He said, I can't tell you. And he was visibly nervous. And I said, it's okay, you can tell me. And he said, no, I can't. He said that he would hurt us, he would blow us up. And I said, well, what do you mean? I said, it's okay, you can tell me. And he told me, he said that JT had a gun and he saw it in the bullet. And I said, well, what color was it? Trying to see if it was real or not, I guess. And he said, well, it was bullet colored. And he was crying at that point, teary-eyed. And I had him come into my classroom, and I called the office to report it. And Mr. Sims answered the phone. And then I went back to my door, and Mr. Rawls was bringing my other student
And before
back
you
to me.
get into Mr. Rawls, why did you feel the need to call the office and report it?
Because R had said that JT had a gun.
Was that the protocol, to call the office and report it to an
Yes.
administrator?
Yes.
And did you send R back to Miss Warner's class,
No.
or did you keep R in your class?
I kept R in my class for the rest of the day. He was visibly scared. He was worried that JT was going to act, which is why he didn't want to tell me to begin with.
And can you describe for me, as you're talking about him being visibly scared, what does that look like?
You could his demeanor, his facial expressions. When I said, it's okay, you can tell me, when the words finally came out of his mouth, he had tears. I was at that point convinced that he had seen something.
Okay. And then you were talking about Mr. Rawls coming down to your classroom. So what happened then?
Mr. Rawls brought my student back to me, and I said, can you talk to him? Mr. Rawls is a guidance counselor, so we rely on them to speak to children when they have some big emotions. And I said, he's scared. He is visibly shaken. Can you please talk to him? And I reported to Mr. Rawls.
Hitting the pause button on this testimony. When we come back, more of this civil trial happening in Virginia. It all comes down to what other people are going to say about what the principal knew. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us this afternoon. We are in Virginia this hour, where the jury is weighing a multi-million-dollar lawsuit filed by a teacher who was shot by an elementary school student. We'll get you back into testimony inside of that courtroom in just a moment. But we do want to check on this verdict clock that is ticking away in the corner of your screen in the Amber Alert murder trial for Dustin Duren. He is a defendant who took the stand in his own defense. He's accused of fatally shooting his girlfriend, the mother of his children, Caitlyn Naffziger, before he took off with their 2 young daughters. And the defense maintains that he suffers from PTSD, that he shot Caitlyn in self-defense. So let's check in on what's happening with this jury. Here's Court TV legal correspondent Kelly Craft with us in studio. Kelly, when we last talked, you thought this would be a pretty quick deliberation. Still early, but we haven't heard anything.
No, we have not heard a peep from them, Julia. Good afternoon to you. So 1 hour and 40 minutes. That's what we are at so far. So the jurors do have a lot to go through in regard to the charges here. And we're going to talk about the charges in just a moment. But earlier today, what did we hear? We heard the closing arguments. And the prosecutor said in this case, this is murder, and basically was pointing to the defendant saying, and he knows it. Where defense counsel talked a lot about PTSD and how he's a Marine and how he went into action because his child was in harm's way. Let's go ahead and listen to a bit of the closings.
The law says a person has the right to use deadly force when they reasonably believe that someone is committing or about to commit a kidnapping. Caitlyn had kidnapped Dustin's child before. She had a plan to kidnap his children again. She told Dustin he would never see his children again, and she was holding Elowen hostage in front of him. Dustin reasonably believed that Caitlyn was committing or about to commit a kidnapping.
This was not an accident. This was not defense of others. This wasn't done to prevent a kidnapping. It was murder. And he knows it. He knows. And that's why he's changed his story over time. He's taken time to craft what he's wanted to say. It's why he's changed what he told the police after he was caught to what he testified to on this stand. It's why he's tried to blame Caitlyn Naffziger for her death. The real victim here, the victim that you're here to decide this case about, is the unarmed woman who the defendant shot in the head.
So the prosecutor there, Julia, making it very clear that this is not a situation of self-defense or the defense of others.
Yeah, really passionate arguments on both sides, really, in front of this jury. Let's talk about, though, the big thing that we know these jurors are thinking about. They heard from Dustin Duren himself. And remind us how he says this all went down. Does it jive with what his attorney said?
You know, Julia, so what he talked about is how in the past maybe they would have some, arguments here and there, but that he never really yelled at her. But when he was describing the moments leading up to the shooting, he was talking about how he did, in that instance, yell at her, and then he proceeded to talk about what he did. Let's go ahead and play a clip from his testimony.
It was like muscle memory. It was like training coming out to where I didn't have to think about what was happening. It was like I was trained for this, and this is what I'm supposed to do. I take the 2 steps over, grab the gun. As I'm taking probably the 3 steps back over, I'm chambering around into the gun. I grab Elowen by the shirt collar, the front of her shirt collar. I pull her forward, not to me. I pull her forward to get some sort of distance between her and Caitlyn, pull her forward, and then fire.
So that was him on the stand. Let's go ahead and take a look at the charges that he's facing. So this could be a reason why it's taking the jurors a little bit longer. An hour and 43 minutes isn't exactly that long, but in this case, maybe one might think it is. So 2 counts of second-degree murder, one under the reckless standard, the other one under the alternative theory. That would be your depraved heart. Also, several other charges you can see there as well. Also, let's talk about the jury makeup here. Even split, Julia. We have 6 men and 6 women. They are going to be deciding the fate. They are right now, and we're getting close to about 2 hours, Julia. We'll have to see if we get a verdict today in this one.
Yeah, generally it's still early, but I think we were thinking this would be really easy for this jury. We will, of course, keep everyone updated when there is a verdict. Kelly, thank you. Let's turn our attention now back to Virginia, where an assistant principal for a school is being sued by a former teacher over allegations of a 6-year-old who shot that teacher. Ebony Parker is the one who's being sued. She's also facing criminal charges for that shooting, but she is not on trial for that here. Let's pick it up with this civil case. On the stand now is a first-grade teacher who would have been a co-worker of the plaintiff in this case.
Told the backpack, that JT's backpack had been checked while we were at recess. And I said to Mr. Rawls, why can't we check his person? R says he had it on him. Can we check him? And at that point, Mr. Rawls left my room.
Let me slow you down right there. So before Mr. Rawls leaves your room, do you see Mr. Rawls talk to R?
I can't remember if I saw the conversation or not. It was right outside my classroom door, and I honestly don't remember where my position was at that point.
Once Mr. Rawls is leaving and R's coming in, what does he look like then? What's his demeanor? How is he acting?
He was scared. I had him sit at one of my tables. A student was absent, so I put him in the empty student seat. And every time he'd get up, he got up frequently and would like side eye to look out the classroom door window. It seemed to me that he was checking to see what was going on across the hall.
When he came back from talking with Mr. Rawls, did he still have teary eyes?
Yes.
Teary eyes. So tell me, where, if you know, did Mr. Rawls go when he left your classroom?
He said he was going to Dr. Parker to ask permission to search JT.
And then did you see Mr. Rawls again that day?
He came back and told me that we were told we could not search him.
Okay. And then did you keep R in your class the remainder
R
of the
stayed
time?
in my classroom even after the incident.
And when you say the incident,
The shooting.
And did you hear the
Yes.
shooting?
Yes.
Okay. Once you heard the shooting, what did you think that was?
I knew it was a gunshot.
And where did you think it had come from?
Abby's room.
Did someone open your door at that moment?
I did.
Okay.
I opened the door, and Abby's class came across the hall. I saw a side view of Abby. I couldn't see her face. I knew that she had been shot because there was blood on the floor, and I saw her hand. And once I got all of the students in, I shut my door and followed lockdown procedures, even though lockdown had not been called yet.
Okay. And R's still with you in the class at that time?
Yes.
And did you see JT at that moment?
I did not.
But you knew at that time?
Yes.
That something had happened. JT had done something?
Yes.
And you knew at that time it was a gun?
Yes.
Okay. Thank you. That's all the questions I have right now. I appreciate it if you'll answer any of opposing counsel or the judges.
Cross-examination.
Thank you, Ron. Ms. West?
Yes.
You're one of the lead first grade teachers at Bishop Elementary School, is that correct?
Yes.
And that was the case back in 2023 as well, right?
Yes.
And by lead first grade teachers, that means that you're in the hierarchy of responsibility there at the school. You have some teachers that work under you, or you have some authority over them, correct?
I don't know that they don't work under me. I'm the lead of the team. What that means is I attend meetings at the district level and disseminate information to my team that way. And I am part of the lead team at the school, but I'm not in charge of any teachers.
That's right. And part of your responsibility as a lead teacher also is you can serve as a mentor for fellow teachers.
It has nothing to do with being a lead. I can choose to be a mentor teacher. I just happen to be both.
And you were a mentor to Ms. Warner.
Yes. The previous year, her first year in first grade.
As her mentor, you kind of showed her the ropes with classroom management. You showed her the ropes with how school works and school operates, and you try to share and impart knowledge to her, right? As her mentor.
Yes.
In addition to having the opportunity to mentor folks, sometimes you have some supervisory responsibilities at the school.
I'm not sure what you mean.
Say, for example, as lead teacher, isn't it typical, or was it typical at the time, that you would have a walkie-talkie if you went out to recess? That would usually go to the lead teacher.
I don't believe it was. I believe it was the first teacher that went out to recess would get the walkie-talkie, so that there was one on the playground regardless of who was out there.
Understood. On January 6, 2023, you had a walkie-talkie.
I did at the end of the day, like after recess. I honestly don't remember having it prior to the lockdown.
On January 6th, the first time you encountered Mrs. Warner was out on the playground at recess, correct?
No, at lunch.
At lunch?
Yes.
That was in Miss Miller's classroom?
Yes.
Correct? And that's when Mrs. Warner came in, had a discussion with you, and you referred her to go and speak to the administration, right?
Yes.
After that, the next time you encounter Abby was on the playground, correct?
Yes.
On January 6th, when you went to recess that day, you got there a little bit late, right? So ordinarily it'd probably be around 12:20, 12:25.
Yes.
You were there around 12:35.
Yes.
Right? And correct me if I'm wrong, but I understand your testimony today to be when you arrived on the playground, Ms. Warner let you know that she suspected or had reason to believe that JT might have a firearm on his person.
I don't specifically remember her saying firearm. I remember in the notes that I wrote down from that day was that she told me she witnessed him take something. I wasn't convinced it was a firearm until I spoke with R.
Okay. Once you arrived on the playground, did she immediately notify you?
Within a couple of minutes, likely, yes.
Okay. Ms. West, I'm going to show you an exhibit which has been marked for identification as Defense 63H. And I just want this to be displayed to Ms. West and counsel.
63H?
That's correct.
All right, while they get that evidence together, let's slip in a break. But what emotional testimony we're hearing from this teacher. It's unimaginable what this must have been like for them. A gun inside of a school and all of these babies, 6, 7, 8 years old, being there potentially in harm's way. When we come back, there's going to be a question about whether or not the plaintiff in this case knew about the gun beforehand. Stay with us.
An Amber Alert triggered by a deadly shooting and 2 girls taken by their father.
But did Dustin Duren shoot the mother of his children in self-defense?
The Amber Alert murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, missing baby Emmanuel's father pleaded guilty to murder. But what's next for the mother? We're unpacking today's big hearing in the case against Rebecca Harrow.
Closing Arguments with Vinnie Politan. Tonight at 8, 7 Central. Only on Court TV.
Back now to Virginia, where a teacher is suing a former assistant principal. And the initial lawsuit was for $40 million. We'll find out during closing arguments what the ask is of this jury. 28-year-old Abigail Zwerner is suing that principal of Rich Neck Elementary School, Ebony Parker, for millions, and says that it's because she failed to act when a 6-year-old brought a gun to school. It's a young boy who had a history of violence, had been out of school because he was suspended the day before for throwing a teacher's phone on the ground. There's a teacher who is on the stand right now talking about some of the things she noticed about that 6-year-old, and right now she is facing cross by the defense attorney that is representing the principal.
Ms. West, can you see that display?
Yes.
All right, I'm going to play a portion of this clip and ask if you recognize the individual who appeared on the screen. Brian, can you play, please? All right, can we pause here, please? Okay, Ms. West, do you recognize, is this a fair and accurate representation of you coming onto the playground at recess time on January 6, 2023?
I don't know. Are you talking about on the sidewalk?
Yes.
I honestly don't know if that's me or not, but it might be.
Sure. You can continue playing, Brian. And that individual who just passed the person in the green sweater, that was Abby Zwerner, right?
Yes.
Okay. Do you recognize yourself in this image now?
Yes.
Okay. So that's you, Miss West, standing there on the playground on the day before the shooting occurs, correct?
Uh-huh.
Okay. Now, you just saw that you passed Ms. Warner on the way out onto the playground. At that stage, she had not informed you?
I don't believe so. I can't say for sure.
Right, and you'll see that in this display, you're the only adult on the playground at this stage.
Okay.
You would agree?
It appears so.
And there's multiple children out there, right?
Yes.
You're the only adult supervising those children, correct?
I mean, that's what it looks like, but there are, we would like station ourselves in other places, so.
Sure, we can continue playing the rest of the clip.
Okay.
But this image here, you're the only adult.
Can be seen by camera, yes.
Correct. Brian, if you could continue playing the clip, please. Brian, let's do... Let's do 63 F, or excuse me, let's do 63I, please. So this is skipping forward. If you could pause here, Brian, please. Miss West, can you see in the upper right quadrant, the upper right corner?
All right, so while you're seeing this evidence being played in court, we can't show it because it's a playground setting with lots of little first graders who are walking around. But you can see that there's really only one adult that's out there, and that is this witness who is on the stand. Right now, it's really difficult to see anyone standing out in terms of the 6-year-old who's at issue here. But that's what's happening inside of the courtroom. That's what these jurors are watching, is that surveillance video that is from the school playground. Let's go in.
We're in the upper right corner of the surveillance image here. Well, Abby Zwerner is across from you on the other side of the playground, correct?
Yes.
Okay. And then, Brian, due to my oversight, if we could go back to the original clip. And just show that for the jury, if we can publish that, please. We'll see Miss West come onto the playground.
All right, while they're watching that video, I want to get some analysis from our guest who is standing by. We have national trial attorney Michael Jaffer with us. Michael, so good to have you on the show. And to talk about this case, because I feel like there are a lot of cases that are similar to this one that I've talked to you about in the past, including the Ethan Crumbley case, where we have parents or someone who is not the child who is the shooter getting found liable. Now, this person here, this principal, she is not, we're not dealing with the criminal case here, but she is facing criminal charges. They are still pending. What are your thoughts on this case and where we are with a principal being found responsible?
This is very typical in the civil arena, right? If anybody thinks that like a
felony case, of a murder case, the defense attorney has a complicated role. You see nothing until you see this case. The plaintiff attorney here have to thread a very, very thin needle. 3 days ago, I predicted that this case would settle before trial. I was wrong, and I think I know why. The defense attorney for the teacher is saying that they have to show that she had a complete depraved mentality towards this, and that they said that a 6-year-old child having a gun and shooting a teacher is virtually unprecedented. I tried to find a precedent. I couldn't find it. So I think they're right. So it comes down to whether or not this principal, and what planet would you imagine a 6-year-old carrying a gun? She said he had little pockets. So this case is very fascinating. I have a case very similar to this right now. Those cases are very, very complicated. You have to thread a very specific needle. So the plaintiff attorneys for Abby's Werner, it's not enough for them to win the case. The whole point is to have your client get paid. Well, your client doesn't get paid by you just winning the case. You have to win it in a very specific way. So you're going to see a lot of very cerebral examinations and cross-examinations. There's going to be jockeying for position with every witness. This is going to be a very complicated case. I cannot imagine how complicated the jury instruction is going to be at the end of this case.
Oh, yeah, absolutely. And I want to ask you this, because a lot of people are asking, why are they going after a principal? She can't have that much money. We're talking about a $40 million lawsuit. First thing, we don't know that this jury is going to be asked to award $40 million. We will know during closing arguments what they ultimately asked this jury for. Also, I want to get your take on the Virginia Risk Sharing Association that is helping. They have liability coverage for public officials like the principal. They apparently are paying for her defense counsel. So do you think they refuse to settle this case just because they are a risk-sharing association? And there's something else that's involved oftentimes when it comes to making that agreement.
You asked the excellent question. This is exactly why they say this case is complicated. The reason that they're suing her is because there's governmental immunity for the school district, right? So you have to, when you file these kinds of cases against municipalities, you have to allege negligence against an actor, against an employee of that agency, a human being. It's not enough to allege it against the municipal, because then people would just sue schools and municipal authorities all the time. You have to allege negligence against a person working for the municipality. In this case, it's the assistant principal. They've identified her as a person who derogated her duties and did the negligent act. That's why they're suing her personally. They have to do it. In terms of the insurance, there's self-insurance from the Virginia Municipal Authority, and so the insurance scheme in the labyrinth is extremely complicated. Just imagine suing somebody who has a labyrinth of insurance and coverage and umbrella policies, and that's when somebody's a private person, let alone a government actor. There's so much, the insurance scheme itself, to get to the insurance and to get to the insurance, to even have them not just defend her, but indemnify her, because it's one thing for them to defend her. It's another thing at the end of the case, if they win, there's going to be another trial after this trial to see whether or not the contract requires them to even pay. Well, that's why you're seeing this.
That is good information, because I know a lot of people are wondering, why are we here? That's a good reason why we are here. Michael J, for standby. We're going to get to our break. Also want to let our viewers know about new developments in the case of the murder of Emmanuel Haro. That missing little boy, still missing. His father already pleaded guilty, but his mother, Rebecca, was in court a short time ago, and unlike her husband, she did not enter a plea. The hearing only lasted a couple of minutes, but her felony settlement conference is what this was called. It has actually been delayed. Attorneys are going to be back in court next month, but this defendant won't be back in court until next January for that conference, and no word on if a plea deal is in the works for her. As I mentioned earlier this month, her husband, Jake Haro, pleaded guilty to second-degree murder, to killing their baby boy, Emmanuel. We'll have more on this story in the next hour. Matt Johnson, who's been there on the ground with all of this coverage, he will join us in studio for a full update. But we'll have more when we come back from the first grader shoots teacher civil trial. Stay tuned. Was a shooting by an armed 6-year-old student foreseeable? That's the question that's in front of the civil jury. Let's get you back inside of the shot by a first grader civil trial happening in Virginia. First, we do have an update on another trial that we're tracking here on Court TV, the bad boyfriend murder trial of defendant Matthew Paul in Wisconsin. He's accused of killing his girlfriend of 20 years, Stephanie Pavlons, and dumping her body in the woods. Earlier today, jurors heard from Pavlons' mother on direct exam. She was asked about her daughter's relationship with the defendant. Take a listen.
Was Matthew welcome in your home?
No.
Why not?
Because of the way he treated her.
Way he treated who?
Like, Steph.
Okay. What bothered you about that?
I just thought it was an unhealthy relationship, and she, I don't know.
We're tracking a lot of trials here at Court TV. We'll keep you posted on that one. Also, the Dustin Duren case in New Hampshire, where the verdict clock continues to tick, 2 hours and 12 minutes. For now, though, let's get you back inside of the case of that teacher in Virginia who was shot by a 6-year-old. She's suing the school's former assistant principal. Abigail Werner says that Ebony Parker failed to act when the 6-year-old brought a gun to school. And the attorneys say that the child had a history of violence and had been suspended the day before the shooting for throwing the teacher's phone on the ground. Picking it up where we left off with testimony of a fellow teacher who was out on the playground with students, and she's being questioned on cross-examination of whether or not she noticed the threat.
Did you feel in fear for your safety?
Honestly, I don't know. I was watching 40-ish children and keeping an eye on somebody that we were unsure.
And after you received the report from Ms. Warner that JT might possess a firearm, and you began watching him, at that point, were you concerned for your safety?
Honestly, I don't know. It is a blur. But again, I don't recall specifically if the word firearm or gun was used at that time. I was convinced that there was a gun after I spoke with R after recess.
Court's indulgence, please. At some stage when you were out on the playground, Ms. West, you had another student who became disruptive, right?
Yes, when we were lining up.
Right. And at that stage, you had already received information that JT might have a weapon, right?
Again, I can't say for sure that the word weapon or gun was used. My notes that I wrote down that day, I just said that it was reported that he took something. I can't speak clearly that I was told it was a weapon.
When you returned to the school to deal with that student, and you got inside, you encountered Dr. Parker.
For about 2 seconds. We walked past each other.
Right. And you walked past her because you were dealing with the other student who had become disruptive on the playground.
I was following him because he was eloping. He was running from me.
He was running from you?
Yes.
And you contacted Dr. Parker and asked for assistance, right?
I don't remember what I said to her, but it was literally in passing. It was not a stop and have a conversation.
And a guidance counselor or
was also in the hallway with Dr. Parker.
Intercepted the child?
Yes.
And took him to the main office to be disciplined?
I don't know where he took him.
When you encountered Dr. Parker in that hallway, you didn't disclose any of the information you had received.
I did not, because I was not convinced until after that when I spoke with R.
So your suspicion that JT might have an actual weapon of some kind didn't materialize until you spoke to RR, is that correct?
I was convinced when I spoke with R.
But up to that point, you had a suspicion?
Yes. And I was focused on my student in that moment, and I don't know why I didn't say anything when I walked past Dr. Parker in the hallway.
When Ms. Warner first reported that the student might have had an item on this person, is it possible that he might have a weapon, right?
It was possible, yes.
And you're familiar with the protocols that were...
To report to an administrator.
But also, is it your understanding that if someone reports that there's a suspected weapon, you should presume that it's legitimate?
I'm not sure what you mean.
So you're not familiar with the protocols?
Oh, I'm not sure what you're asking. Can you ask that again?
I'm asking that you had received information that the student might have something that may or may not be a weapon, correct?
Yes.
Okay. And despite that knowledge, you remained on the playground with multiple students?
Yes.
You allowed that child to continue playing? You allowed the child to continue playing with other children?
What should I have done?
Detain them?
You can't. How was I supposed to detain him?
Isolate them? Evacuate the area?
Okay, an
Use
alert.
the walkie-talkie to contact the...
That's not something you would put over a walkie-talkie.
You wouldn't want to share with the school that there's a suspected weapon?
You wouldn't alert the entire school over a walkie-talkie that there's a suspected weapon.
But you would allow a child in possession of a suspected weapon to commingle with other children?
It was my understanding that Dr. Parker had been made aware by another teacher while we were at recess.
And so you took no measures to isolate this child, to detain him?
I did not try to isolate him, no.
Rather, you prioritized disciplining another student?
It wasn't disciplining, he was eloping. And I was keeping him away from harming somebody. He was putting his hands on another student.
Right, you perceived that as an imminent threat to that student? That's why you followed that student, correct?
Because I witnessed it, yes.
And you took action on it, right?
Well, I opened the door and he ran.
And you left the playground when you did that?
I did.
And JT remained on the playground when you left?
Yes.
With the other students?
Yes.
With a potential firearm?
That Dr. Parker had already been made aware of.
You had received no confirmation that she received any information to that effect?
The confirmation came from my coworkers telling me that she had been made aware. I spoke with
coworkers who remained on the playground with you?
One of them, yes, but one of them was not on the playground.
Ms. West, you've testified that when you left JT on the playground, you didn't know whether or not he had a weapon?
I was not confirmed, no.
But your testimony today was that you didn't even think that he had a firearm?
No. I said it was suspected. I didn't know what it was. Once I questioned R, and he told me that he had seen a weapon, and I saw how scared R was, how visibly shaken he was by the threats of harm from JT. That's what convinced me that it was a weapon.
And let's fast forward a little bit. Once you spoke to R about the reports or information he received about JT, that's when you decided to contact the administration, right?
Yes.
But you didn't go there directly?
I couldn't go.
Hitting the pause button on this testimony. We've got to get to a break. Who dropped the ball? That's the big question here. And we're going to listen to this witness talk about what she may have told the plaintiff. The teacher, what did she have in terms of personal responsibility? That's up next.
I ended up asking him if he loved me. He said, I don't know. I said, do you love her? He said, I don't know.
That set you off?
Someone was stabbed?
Yeah, she's on the floor.
I didn't have the intent to kill Sarah. I really just wanted to scare them.
It looks more like fury than fear. Did you kill Sarah to possess what she had with Josh?
Sorry.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
Let's go to Virginia for the first grader shoots teacher civil trial. Teacher Abigail Zwerner is suing her former supervisor, assistant principal Ebony Parker. She was shot by her 6-year-old student back in January of 2023, and she says the principal repeatedly ignored warnings about the child's violent behavior and that he was armed with a gun. And we're hearing about some of that suspicion. Inside of the courtroom on the stand is a fellow teacher who believed that the student had a gun, and she's facing cross by the principal's attorney, questioning her about what she did or didn't do after learning about this threat.
But you didn't go there directly.
I couldn't go there. I had a classroom full of children.
But you left them on the playground before last time.
They were getting in line with another teacher.
You only leave children on the playground when you suspect one of them has a firearm?
That's never happened before or since.
In place? It happened on January 6th.
You are correct. But there was no protocol in place for that other than report to your administrator.
There was no protocol in place?
I mean, it was report to your administrator, and it had been reported.
So, meanwhile, while you had information that a child might have a weapon, you allowed children to remain on the playground unsupervised?
Judge, objection. This question has been asked and answered numerous times at this point. Her answer is not going to change.
I can move on from this.
That objection is sustained.
Thank you.
Ms. West, you testified that when you arrived on the playground, you weren't told specifically whether or not JT had a gun?
That's what my notes, I wrote down notes that night, and that's what my notes say.
You roll call testifying in a deposition in this matter?
Yes.
You remember being placed under oath?
Yes.
You swore to tell the truth?
Yes.
Brian, if you could pull up page 73 of the August 13th, 2025 deposition.
Remind, what was the page number again? Just for my
It's page 73.
All right, while they're pulling up that deposition transcript there, let's bring in a trial attorney, Michael Jafer, who is watching along with us. What we're getting to inside of the courtroom, Michael, it's this allegation that this teacher told or said during her deposition that the plaintiff, who we're seeing there on the left, that she told her that this student had a gun. Does that, do you think, really impact the jury if they think that there's a possibility that she could have held some personal responsibility? We know that's what the defense is saying.
Absolutely, and it comes down to how, if they win, how they win and what findings they have. It absolutely will sway the jury. This is obviously not a criminal trial, so everybody can be deposed, and they have to be deposed, and they have to go on the record, and they have to answer questions under oath before a trial even begins. And so, yes, it will absolutely make a difference, and it clearly is making it. Clearly, the attorneys are bringing it up at trial for a reason. Yeah.
What do you think about the credibility of this teacher? She knew some things prior to, and they're asking, why didn't you do more?
I think her credibility is because she's coming off very credible to the jury. I think she's coming off very credible, and I think it'll be a factor.
All right, let's go back in.
Preceding this trial, was that Ms. Warner had reported to you that this child had, in fact, a firearm?
That's what I said then, yes.
And you were unequivocal at that stage?
I don't recall. It was an emotional time during the deposition.
I can imagine it would be an emotional time on a playground when a teacher reports that a child has a gun, right?
It would, sure.
Yet, you left him on the playground thinking that he had a gun, and you didn't do anything.
Judge, again, I'm objecting. It's been asked and answered a few times. Thank you.
I have no further questions. Please, Judge.
Before you sit down, did you show a second video clip, or was that a clip that you showed?
There were multiple clips. I think there was
63I was the second one.
All right.
That's correct.
That's Brian, by the way, for the transcript. All right. Redirect.
Just one question, Your Honor. Can you tell the jury who was the teacher that you understood was telling Dr. Parker while you were at recess that they thought JT had a gun on the playground?
Amy Kovac, her reading specialist.
And I guess second question, who did you think she was telling that to?
Dr. Parker.
Okay, thank you.
All right. Any follow-up based on that?
One question. The reason you thought Ms. Kovac reported to Dr. Parker was because you had spoken to Ms. Kovac, correct?
I don't believe I've spoken to her. I believe I was told.
So, and you weren't present for that conversation?
No.
You had no direct knowledge whether or not she actually communicated with Dr. Parker that way?
I guess not, no.
No further questions, Judge?
All right. Is she excused, or do you want her resequestered?
Your Honor, I'm fine releasing her from our subpoena. I know she has been subpoenaed by defense as well, Judge.
Okay, and you reserve the right to call her?
Judge, we reserve the right to call.
Okay. All right, but she can go for today?
Yes, Your Honor.
All right. Ms. West, I'm going to release you from your testimony from being in court today, but you are still considered a witness in the case, so you're not allowed to discuss this testimony or anything you've heard or testified to about this case with anyone, all right? And do you have her number to reach her?
Your Honor, I did want to also ask that you can instruct the witnesses who are still under subpoena not to watch any coverage on TV.
Correct. Yeah, absolutely. And obviously, no watching of any reporting of any of this until you are, if and when you are called back or released for good from this case. Okay?
Good reminder, no witnesses, no jurors should be watching court TV. But we're all watching this, and Michael Jafer is still with us and watching this. Michael, I know a lot of people are wondering, what about the parents? Is that where the buck stops here? These teachers have an important, but sometimes it's seemingly impossible job. I was a kid of a teacher, so I think I'm even more sensitive to what all teachers deal with on a daily basis and never make it into a courtroom. No one ever even acknowledges what all they are dealing with. But we have here the responsibility falling beyond the teacher to the principal.
100%. A 6-year-old kid brought a gun to school. I have a 6-year-old right now. He's in my house. How would they even know how to operate a gun? This is actually unprecedented. The responsibility, in my opinion, goes directly to the parents from a criminal standpoint. I know that she's also, the assistant principal is facing criminal charges, but this is an unprecedented situation. It's fascinating me. It's just not even as an attorney, as a parent, I'm riveted. I want to see how this saga plays out.
Yeah, and the mother is actually serving on felony charges in this case for child neglect. But you have the principal here facing felony charges as well. Do you think that that's going to impact whether or not she takes a stand? Because when we have a civil trial, usually the plaintiff can call the defendant. But here I'm not so sure, since she's going to have to face a criminal jury.
That's a great question. Actually, you know what? That's going to be riveting to know as well, whether or not she takes the stand. She has the right to plead the fifth. You can't avoid testifying in a civil case unless you are facing a criminal case. So she can, in fact, do that. And obviously, they did not postpone this civil trial like they did in other high-profile cases for the criminal case to finish itself. So she can avoid taking the stand. Whether or not she should, I think she should take the stand, because at the end of the day, you have a
Honorable Jonathan S. Gazelle presiding. Please
Thank you.
remain standing for the oath of jury.
Thank you. Please be seated.
Mr. Duren, if you could remain standing and face the jury. Madam Foreperson, will you please stand? Has the jury reached verdicts? Yes. How say you, Madam Foreperson, is the defendant Dustin Duren guilty of the crime of second-degree murder, recklessly causing the death of Caitlyn Naffziger, as charged in the charging document identified with charge ID 2217221C, or not guilty? Guilty. You say, Madam Foreperson, the defendant is guilty? Yes. So say you all, ladies and gentlemen of the jury?
Yes.
How say you, Madam Foreperson, is the defendant Dustin Duren guilty of the crime of reckless conduct with a deadly weapon, as charged in the charging document identified with charge ID 2217222C, or not guilty? Guilty. You say, Madam Foreperson, the defendant is guilty? Yes. So say you all, ladies and gentlemen of the jury?
Yes.
How say you, Madam Foreperson, is the defendant Dustin Duren guilty of the crime of endangering welfare of a child, as charged in the charging document identified with charge ID 2217223, or not guilty? Guilty. You say, Madam Foreperson, the defendant is guilty? Yes. So say you all, ladies and gentlemen of the jury?
Yes.
How say you, Madam Foreperson, is the defendant Dustin Duren guilty of the crime of second-degree murder, knowingly causing the death of Caitlyn Naffziger, as charged in the charging document identified with charge ID 2237508C, or not guilty? Guilty. You say, Madam Foreperson, the defendant is guilty? Yes. So say you all, ladies and gentlemen of the jury?
Yes.
Thank you, Madam. You may be seated.
Your Honor, could you poll the jury, please?
Certainly. Defendant has requested to poll the jury.
Yes, Your Honor. Juror number 3, will you please stand? Sir, in your individual capacity as juror, how say you, is the defendant Dustin Duren guilty of the charge ID 2217221C, second-degree murder, reckless, or not guilty?
Guilty.
How say you, is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty?
Guilty.
How say you, is Dustin Duren guilty of charge ID 2217223C, endangering welfare of a child, or not guilty?
Guilty.
And is Dustin Duren guilty of charge ID 2237508C, second-degree murder, knowing, or not guilty?
Guilty.
Thank you. Have a seat. Juror number 6, if you could stand in your individual capacity as juror, how say you, is the defendant Dustin Duren guilty of charge ID 2217221C, second-degree murder, reckless, or not guilty? Guilty. How say you, is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty? Guilty. How say you, is Dustin Duren guilty of charge ID 2217223C, endangering welfare of a child, or not guilty? Guilty. And how say you, is Dustin Duren guilty of charge ID 2237508C, second-degree murder, knowing, or not guilty? Guilty. Thank you. Juror number 7, if you could stand in your individual capacity as juror, how say you, is Dustin Duren, is Dustin Duren guilty of charge ID 2217221C, second-degree murder, reckless, or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2217223C, endangering welfare of a child, or not guilty? Guilty. Is Dustin Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty? Thank you. Have a seat. Juror number 8. In your individual capacity as juror, how say you is the defendant Dustin Duren guilty of charge ID 2217221C, second degree murder, reckless or not guilty? Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty? Is he guilty of, is Dustin Duren guilty of charge ID 2217223C, endangering the welfare of a child, or not guilty? Is Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty? Thank you. Juror number 9. In your individual capacity as juror, how say is the defendant Dustin Duren guilty of charge ID 2217221C, second degree murder, reckless or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2217223C, endangering the welfare of a child, or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty?
Guilty.
Thank you. Juror number 10. In your individual capacity as juror, how say is the defendant Dustin Duren guilty of charge ID 2217221C, second degree murder, reckless or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2217223C, endangering the welfare of a child, or not guilty?
Guilty.
And is Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty?
Guilty.
Thank you. Juror number 11, in your individual capacity as juror, how say is the defendant Dustin Duren guilty of charge ID 2217221C, second degree murder, reckless or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2217223C, endangering the welfare of a child, or not guilty? Guilty. And is Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty? Guilty. Thank you. Juror number 12. In your individual capacity as juror, how say is the defendant Dustin Duren guilty of charge ID 2217221C, second degree murder, reckless or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2217223C, endangering welfare of a child, or not guilty?
Guilty.
And is Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty?
Guilty.
Thank you. Juror number 13. In your individual capacity as juror, how say is the defendant Dustin Duren guilty of charge ID 2217221C, second degree murder, reckless or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2217223C, endangering welfare of a child, or not guilty?
Guilty.
Is Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty?
Guilty.
Thank you. Juror number 14. In your individual capacity as juror, how say is the defendant Dustin Duren guilty of charge ID 2217221C, second degree murder, reckless or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2217223C, endangering welfare of a child, or not guilty? Guilty. And is Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty? Guilty. Thank you. Juror number 15, in your individual capacity as juror, how say is the defendant Dustin Duren guilty of charge ID 2217221C, second degree murder, reckless or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2217222C, reckless conduct, deadly weapon, or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2217223C, endangering welfare of a child, or not guilty? Guilty. Is Dustin Duren guilty of charge ID 2237508C, second degree murder, knowing or not guilty? Guilty. Thank you. And juror number 16, in your individual
Okay, any further requests at this time? Okay, please be seated. Okay, members of the jury, I want to thank you for your service, and in a moment I'll have you retire to the jury deliberation room. I'll come in and see you in just a moment, and thank you again for your service. Anything further on behalf of the state before I dismiss this jury?
No, Your Honor.
Anything further from the defendant before I dismiss this jury?
No, Your Honor.
Okay, thank you. Please rise for the jury. Thank you. Please be seated. State's position on bail.
Your Honor, the state would ask that bail remain at no bail.
Any response from the defendant?
No, Your Honor.
Okay, all right. Bail shall be, no bail will be continued, and I would like to address the jury sooner rather than later. Next thing would be the court would order a pre-sentence investigation from the New Hampshire Department of Corrections, and a sentencing date will be determined. Obviously, the Department of Corrections will need a certain amount of time before a pre-sentence investigation report can be completed. Do we have a tentative date, or we would?
Yes, Your Honor, there is time on the docket on December 11th at, starting at around 10 a.m. Does that work for counsel?
I can just check, Your Honor. We have a lot of family members. That's about 45 days. The state can make December the 11th work. How much time would the court have available for us on that date for a hearing?
At this time, Your Honor, from 10 a.m. on is there's free time, so.
That's fine with the state.
I'll state, my concern is I want to make sure that during the month of December, obviously, there's other things that also occur that sometimes interfere with the participation in these sorts of matters, but we will take that under advisement under the circumstances. Anything further at this time from the state?
Nothing from the state.
Okay, any, defense counsel, anything further at this point? Okay, all right, I will speak to the jury. The matter is concluded. Mr. Duren, I remand you back to the custody of the Coast County Sheriff's Department. The court will be in recess.